source of the recorded information could testify if called as a witness, generally excluding, however, in criminal cases, matters observed by police officers and other law enforcement personnel when offered against a criminal defendant. In business records, Ms. Jenkins, are you going under 6 in records of regularly conducted activity?
Let me check the number. Yes, Your Honor.
In reading that, so saying section rule 2:803, paragraph 6, records of a regularly conducted activity. A record of acts, events, calculations, or conditions if, paragraph A, the record was made at or near the time of the acts, events, calculations, or conditions by, or from information transmitted by someone with knowledge. Paragraph B, the record was made and kept in the course of a regularly conducted activity of a business, organization, occupation, or calling, whether or not for profit. Paragraph C, making and keeping the record was a regular practice of that activity. Paragraph D, all these conditions are shown by the testimony of the custodian or another qualified witness, or by a certification that complies with Rule 2:902, paragraph 6, or with a statute permitting certification. And paragraph E, neither the source of information nor the method or circumstances of preparation indicate a lack of trustworthiness. Okay. All right, so again, we're back with parts of the Newport News School Handbook. Commonwealth seeking to introduce them, defense is objecting. Would the defense like to flesh out their objection?
Your Honor, I'll start with the record for regularly conducted activity. I would say that those handbooks are definitely not those. This contemplates records that are basically prepared from day to day, indicating the daily activities, business transactions of that business. That's not what we have here. We have basically our policies and procedures book. A says the record was made at or near the time of the acts, events, calculations, or conditions. That's definitely not met. So the record was made and kept in the course of regularly conducted activities of the business. Your Honor, these are one-time documents that gets produced once or once a year, maybe once every couple of years, and making and keeping the record was a regular practice of that activity. This isn't a record. This is a policy and procedure handbook, and it doesn't qualify as a record of the regularly conducted activity. So all of those conditions have to be met, which is capsulated in paragraph D.
Okay, and with respect to paragraph 8, public records and reports.
Regarding the public records and reports, I would submit that policies and procedures handbook is not an exception based on a statute, made and misspoke by statute, and it's not a record or report or a statement or data compilation. So I would submit that it doesn't qualify under that paragraph either.
Okay. Anything further from the Commonwealth?
Yes, Your Honor.
And again, we're going one by one.
Okay, so with respect to the manual being a business record, start with that one. I'll ask the court to rely on the case of Carmody v. F.W. Woolworth. Carmody is C-A-R-M-O-D-Y. The F.W. Woolworth, W-O-O-L-W-O-R-T-H company. It is 234 VA 198. In that case, an employer's employee manual was admitted under the business records exception to prove what a particular employee's duties were. And the court held that it was properly admitted under the business records exception. And so that case establishes a business records exception, and the Supreme Court has said that an employee manual, if kept in the regular course of that business, is admissible under that exception. I'll turn to the exception for public records as well. Actually, Judge, as to public records, give me just one moment.
Yes, sir.
As to public records with the school handbook, the policy handbook, it is a report prepared by a public official, that being the school board, pursuant to the nature of their office. So it requires that they, by nature of their office, produce policies that relate to the schools under their direction. And given that, it's admissible under Williams v. Commonwealth, that's 213 VA 45, 1972, among 3 or 4 other cases about public documents. I will have a different argument on that related to the crisis management.
All right, anything further as to the Newport Municipal Public School handbook?
Right, can I have just a moment to look at that Williams v. Commonwealth?
Yes, sir.
Site was 213 VA 35.
I cited the last Williams v. Commonwealth is 213 VA 45.
case?
Yes, sir.
Okay. So it really does not support the Commonwealth's position. It is a case where the Commonwealth is attempting to get information from the Central Criminal Records Exchange. And the rule it's referring to, it says it's generally recognized, it is a generally recognized rule that records and reports prepared by public officials whose duty imposed by statute or required by the nature of offices or municipal proof of the facts. And it goes on to say, but the mere fact that a record report qualifies as a public document does not automatically overcome zero. Say protection.
Talking too fast for the Madam Court.
I'm sorry. Unless the document relates facts or events within personal knowledge and observation of the recording official to which he can testify should be called at trial. That's not what we have. So, that does not support the Commonwealth's position.
Thank you. So regarding the Newport News School Handbook, oh, yes, sir.
Mr. T is reminding me, the very first case, it's a civil case and it's not a criminal case, so it doesn't apply.
Thank you. So the hearsay exception of public records in Newport does apply to the Newport News Public School Handbook. And we can distinguish the cases as Williams refers to the CCRE, which is a criminal record database in history. And again, which is a different public record. And again, there are exceptions for public records compiled by law enforcement. And then again, defense sorry to distinguish a civil case. But this clearly falls within the statute as a permissible exception to hearsay. So the Newport News Public School Handbook comes in. Now, the Richneck Crisis Management Book. Can you first explain to me what this is? I don't know. I need more understanding.
Yes, I can proffer that if the court wants. Dr. Parrish is here and knows more than I do. But the crisis management plan is a document that the school board is directed to require individual schools to create and to update annually. This comes from Virginia Code 22.1-279.8D, where the school board is required to ensure that every school in the district produces a crisis management plan, reviews it annually no later than August 31st, and then the school board certifies in writing to the Virginia Center for School and Campus Safety that that annual review has been done each year. So it is a report, it is a plan required by statute. The contents of the plan generally is it outlines how faculty are to respond, and employees, faculty and employees, are to respond to all various manner of crises that could occur in a school building. Not just violence, but just any sort of crisis, a fire, a natural disaster is covered. Many things are covered.
Are there scenarios that are factually close to the facts reported, in this case, covered in the crisis management book?
Specifically in the crisis management book, there are instructions built on what to do if a suspected weapon is in the building and what to do if an armed student may be in the building.
Okay.
And let me just add, Judge, exactly in both of these documents that I've seen you admit, my plan is to just admit the portions I believe are relevant via the testimony. And I wouldn't even seek to introduce the entire document. However, if the defense wishes for completeness to introduce the whole document, I would not object to that either.
Okay. And then you said you had additional argument on why this is admissible. If you'd like to go into that now so that they can get their cases together and be ready to respond.
Yes, Your Honor. For the crisis management plan, the strongest argument for its admissibility is the public documents exception. And that's because they are required to do it by statute. And that's one of the requirements of the public documents exception, is that either it be required by the nature of the duty or it be required by a statute. And here it is required by a statute. That statute is 22.1-279.8 D, where the creation of the management plan and its annual updating is required by law. Given that, it qualifies as a public document, and we should be able to authenticate it by use of the custodian of records who is here. It is also a business record, I believe, Judge, for the same reasons that the manual is a business record, but I believe the stronger grounds for its admission is the public documents exception.
Thank you, sir. Yes, Mr. T.
Your Honor, regarding the handbook and this, the manual that was just referenced by the Commonwealth, the issue with these documents coming in is that it's going to be very dangerous and can confuse the jury. This is a criminal case. The handbook and the manual cannot set a criminal standard here. They're containing, as Dr. Commonwealth has stated, there's a plan in place for what is supposed to happen in certain situations. I believe that the jury may confuse that with a criminal standard. This is a criminal case, it's not a civil case. The criminal case, the criminal standard is much higher than any, and it's not governed by the Newport Public Schools handbooks or manuals. So while they may be relevant to the standard of care knowledge by an employee, they cannot be used in the analysis of criminal culpability. Additionally, the manual and the handbook presuppose supports that were not present at Richneck Elementary School that day. In the manuals, it contemplates that there's a school resource officer in the building. That is not present here. So there are supports in those manuals and handbooks that are assumed that are not present in this case. And we object to the admission of both.
May I respond briefly?
Yes, sir.
The arguments of counsel just now are fair arguments for him to make as to the weight of this evidence, but those arguments don't go to admissibility. The admissibility is defined by the rule and the case law, and I understand counsel's position that there's little relevance is what it sounds like, but there's certainly enough relevance that it should be admitted, and that argument that we just heard could be made to the jury.
So, in respect to the Richneck Crisis Management Manual, the court does find that it qualifies under the hearsay exception of public records and reports. Now, I will say there, because it is required by statute, doesn't make it admissible by statute, but it meets all other requirements of the public records and reports. And just for parties' edification, I do not find that these will qualify neither the public school handbook or crisis management manual under the records of a regularly conducted activity, as it has to be established that it was made at or near the time of the act or events or calculation. Annual manuals are different from a receipt, a purchase receipt. At this time, can't say I bought this item then, which is a business record made at or near the time of events. That had not been established, so it would not come under that exception, but it does come under the other exception. All right, the third matter is the interview with Dr. Farish, a video interview. Now, I don't know what this is. I don't know what it's purporting to put in evidence. I don't know when it was reported. So if you could proffer to me some of that, and then we'll get into why you believe it's admissible and why they're objecting.
Yes, Your Honor. The video was recorded as part of an internal school investigation by Newport Public Schools Human Resources. The interview was conducted over Zoom. On the recording of the Zoom, you can see that Dr. Nina Farish from Newport Public Schools, the HR director, is asking questions of the defendant, Dr. Ebony Parker. The video, I don't remember its total length, but in the video, the HR director is asking several open-ended questions about the incident at Richneck Elementary, and Dr. Parker is answering those those questions about the incident.
Okay, and do we know the date or when was that taken in relation to the incident, to January 6th? I believe it was 2023?
Your Honor, if I could have just a moment
Yes,
to look
sir.
that up, I think I can. Fine. Your Honor,
Yes, sir.
if I may, what I can tell the court myself is that the the HR director was assigned to do this report and began her investigation on January 9 of 2023. As to what day she interviewed the defendant, I don't know, but she is here, and I'll be happy to have her testify to that.
Okay, if we need to get to that part. And you believe this is admissible, you said, under admission by a party opponent?
Yes, exactly as any criminal defendant's statements or confessions would be admissible. It's both party opponent, and a statement against interest.
Okay, all right, and let me read those into the record. So again, under Rule 2:803, paragraph 0, admission by party opponent. A statement offered against a party that is A, the party's own statement in either an individual or representative capacity, or B, a statement of which the party has manifested adoption or belief in its truth, or C, a statement by a person authorized by the party to make a statement concerning the subject, or D, a statement by the party's agent or employee made during the term of agency or employment concerning a matter within the scope of such agency or employment, or E, a statement by a co-conspirator of a party during the course and in furtherance of the conspiracy. And give me the second one, Mr. Jenkins. What paragraph am I looking for?
Judge, I called it a statement against interest, but I think that really is encapsulated in the Virginia rules as an admission.
Okay, yeah, the other one has to deal with property only.
Yes.
Okay, all right. Okay, all right, defense.
Your Honor, regarding the statements that my client has made, there's really have no reason to object to any of her statements. Again, problem that we're having is the video, indicating the video that Ms. Ferris testifies, that's a statement that my client made. Can't object to that coming in. But as far as playing video without proper identification,
Okay, understood. And all of these are still subject to all of the other rules of evidence, especially regarding authentication. But we were just trying to get those out of the way. Okay, so then there's an interview with Dr. Farish. Again, assuming it meets other admissibility requirements by law, it comes in. All right, anything else we need to take up other than the juror issues?
No, no problem.
Your Honor, Mr. Teague has also advised me that we definitely have concerns regarding the actual interview, course and nature of the interview, that said in when the client felt like she had a right to not give those statements. Rather, we definitely believe that as far as the video is concerned, playing that for the jury would have a profound prejudicial impact on the jury, and we would ask that, even though it's relevant, that the court exclude based on the prejudicial nature of the statement.
Okay, and did you receive this in discovery?
I did.
Okay, why didn't we deal with that in the pre-trial motion?
I'll submit it.
Okay, you've made your position for the record, but it is going to be allowed in. Okay, so we have two juror issues. I'm sorry, go ahead, Mr. Rogers.
You said it's going to be, her statement's going to be allowed in, but at this point,
Again, it still has to meet other rules of
Okay.
admissibility, but in terms of you saying that she didn't have counsel, she didn't know that she didn't have to participate, those things could have been done prior to trial and were ordered to be done prior to trial, and they were not, so I'm not considering anything else regarding that. Now, we had one juror state she had a question, and we had one juror indicate he would like some clarity regarding objections to stricken evidence. My position was to have the juror who had the question write it down with the juror number, and we read it out here on the record, and then I'll ask attorneys how they want us to respond to it. Do you all prefer to proceed in a different format?
That's fine for the comment.
that's fine.
Okay, and again, they are not to be deliberating. So do you want to have just that one juror brought out here and write the question down so that it's not in front of the other jurors? Or do you want the question asked in front of all of the jurors? Or just pass us a sheet of paper?
I'll defer to the defense on how they want that.
Your Honor, we have no problem with her just writing it down, not being viewed by the other jury members and
Okay, so Sheriff Sobchak, and I don't know her juror number, but it was the young lady who sat in the first row far left. If we could have her write it down, and Madam Clerk will give you a sheet of paper with her juror number and to write down her question and just fold it out so that the other jurors can't see it, and we'll bring it out here and read it on the record. Thank you very much.
No problem.
While that is happening, we did receive several media requests for copies of Commonwealth One, the video being played, and it has not been sealed to this point. The parties have a position to that. So that would be the video of Ms. Kovac having JT in a bear hug, which was not played, but I just want the parties to know the media is asking for it. As of now, it's open and not sealed.
Judge, I would ask to seal it because a minor is depicted in the video.
Okay, that's, I just want to know your position.
Right, I support the Commonwealth's position.
Okay, so Commonwealth One will be marked sealed. Thank you. You need anything else, Madam Clerk? You can sign that. Okay, did he bring up a question?
He did, it did not have the juror number on it.
Thank you. All right, juror number 38. What is written on this paper reads as follows. What are the 8 felony counts? The time from recess to shooting? Did VP make 911 call? How would parties like the court to respond? And I'm happy to pass, Sheriff, you can pass that down, they can each see the sheet of paper.
I believe that the court should trust the jury members are going to have to rely on the memory of what they perceive that.
I think that's true, but I think also that they have to rely on their memory, and because the trial is still ongoing, that they have to rely on their memory and any evidence the court admits during the course of the trial.
Okay, and again, the court concurs, so that juror will be instructed to rely on their recollection, but wait till the conclusion of all evidence. There will be more evidence presented, and to not start deliberation until the case is given to them. So, yes, Mr.
On that point, Judge, I feel like it is incumbent on us to adhere the jury members, both based on her question and the gentleman's question.
Yes, and the gentleman, absolutely, but you want to voir dire her as well regarding if she's spoken about this with other jurors?
Yes, only for that limited purpose, whether she's spoken about it with other jurors. I certainly don't want to ask any questions about these 3 things she mentioned.
Okay. Defense position, if any.
I agree that that one's involved.
Okay, and so that we have a game plan for when she comes out here, we're just going to keep it to are these her questions alone? Has she discussed any of the case with other jurors?
Yes, and I would submit that the court can do the inquiry for
Okay.
us.
I just want to be, okay.
And I would ask that court part has she observed any other jury members discussing anything pertinent to the trial?
Okay, those will be the 3 questions. All right, thank you. Okay, so Sheriff, if you can bring out just juror number 38, please.
Yes, sir.
While she's coming out, again, I don't know who the gentleman was, his number yet, but absolutely we will voir dire him individually for the basis of his question. Yes, sir. Good morning, yeah, you can have a seat in the jury box, thank you, and good morning to you.
Good morning.
Okay. And I do want to remind you, of course, you're not being recorded, you're not on video, you can have a seat. Your face and information will not be displayed to the media. Okay, so first, I did receive the answer to your questions, and I have 2 responses. And my responses are required by law. One, you have to rely on your recollection of what the evidence is. And 2, evidence is still being presented to you. So please don't make decisions or deliberations until the case is given to you for deliberation, and that will be at the conclusion of all of the evidence. And I can't you have to rely on your recollection because the court doesn't want to give undue weight or influence or suggestion to any one piece of evidence over the other. That's why I'm not answering your specific questions. So I don't mean to be rude or disrespectful, but you have to rely on your recollection. So now, we have one question for you, or maybe two questions. Are these your questions alone, or have you discussed this with other jurors?
No, my questions alone, like yesterday, we had it, and it was like, and I guess I missed some of that information when it was given, because I wasn't writing everything down. I wanted to listen to everything that was going on. So I may have missed if those answers to some of that.
Okay, understood. And have you observed any other jurors discussing the case? Because they're not supposed to discuss the case until it's given to them for deliberations.
No.
All right. Thank you, juror number 38. One moment, let me see if the attorneys have any follow-up.
I don't.
I think that
Okay, all right, thank you very much. Yeah, you can go back to the room, and we have one more thing to do, and then we'll get started with evidence today. Sheriff, the gentleman in the back row far right, you know who it is?
He's just trying to ask you a specific question. He wants to ask, he wants to talk to you.
Okay, yes, so bring him out. I don't know his number.
Thank you.
Oh, good morning, sir.
One second.
You're welcome to have a seat. Thank you very much. And if you can give me your juror number.
Juror 33.
Thank you, juror number 33. All right, and again, I do want to remind you, your face is not being filmed and your information will not be released to the press. Okay, yesterday you had a question, and so we would like to hear your question, and then we'll decide how to respond, and then we may have questions for you. So yes, sir, juror number 33, what was your question?
In this case so far, there have been a number of objections and information we've been told to omit from our consideration. In the event that while we are taking our notes and trying to recall information, we are unclear about what information is to be omitted, are we allowed to ask for clarification from what point in a witness testimony or from what point in conversation we are to omit from?
Okay. And I'm now going to turn to the attorneys. My position is by law that we give the response of you have to rely on your recollection as best as you can. Does Commonwealth wish a different response?
No, not on that issue, Judge.
Does defense wish a different response? And I do understand we're going to ask some other questions about the lead part. But Mr. Rogers, can the court clarify the objections and what was stricken and not stricken?
I don't have a problem with the court clarifying.
Okay.
As I did before.
What, giving the same response or offering clarity? Giving the response that he has to rely, the jurors have to rely on their independent recollection.
That satisfies.
Okay. Ms. Steve?
Yes, Your Honor, I think my clarification that not only do I think rely on their own recollection, but again, to instruct them that anything that you have ruled that should be stricken or should not be taken into account should be just done just so, considered or handled just so. They cannot consider.
Okay, thank you. Okay, so juror number 33, and that is the response that the court is required to give by law, is that the jurors have to rely on their independent recollection of what the evidence is, and they cannot consider something that's stricken. Now, I understand your point. Well, what if I don't remember what was struck or not, and I got confused and the sustained, overruled? You can consider this, you cannot. Again, you have to rely upon your recollection as best you can. The fundamental principles in the Supreme Court law regarding that are that I don't want to, they frown upon the court giving emphasis to certain evidence over another. So that's why we don't try to clarify. You have to receive it and make your best judgment. Because if I point it out for you, that can give it undue weight. other jurors expressed the same confusion?
The other jurors have not expressed that confusion to me. I posed that question to the other jurors and none had an answer.
Okay, and other than that question being posed to other jurors, have they discussed the case? Are you observing anyone discuss the case?
No, ma'am.
Okay, and the reason why I ask is because you're not to discuss the case, which is deliberate, until it's formally given to you at the conclusion of evidence. So there have been no discussions about the case.
No, ma'am.
Okay, all right, I'm going to turn to the attorneys to see if they have additional questions for you.
Understood.
We don't have no question.
Okay, Mr. Jacobs?
I don't have any questions.
Okay, thank you, juror number 38. You can retire to the room. We have one more thing to take up and then we'll start the case.
Thank you, ma'am.
Correction,
Oh, you do have a question?
No, quick correction. Just now, we referred him, the court referred him as 38.
No, 33. Thank you, 33. Juror number 33. I'm sorry, thank you. You retire to the room.
Thank you, sir.
Okay, now anything that someone would like to address before we bring the jury out?
Your Honor, can I just step out for a quick minute?
Yes, sir. Yeah, okay. I can just meet you in the back end.
We can go in the back. Well,
Okay,
we can go in the back.
I'll meet in the back. Keep your seats. one moment, but back to juror number 33. Anything in addition to this, or any comment on his responses?
Yes, sir. Regarding juror number 33, I think what's most telling is what the juror stated while he was not being asked direct questions about whether they've discussed the issue or discussed the case. Several times he used the word "we," indicating that there had been deliberating before a discussion of the case between the jurors. He stated that he asked a question about the objections and what they're to consider and what they're not to consider. And nobody could give the answer to that question. That indicates that there was discussion about the issue that he raised with the court. Moreover, the issue or the questions raised by juror number, I can't remember.
Was that the young lady?
Yeah.
38, she's 38.
38. Your Honor, frankly, I think those questions were improper and have, kind of aided the conduct with knowing what's important to the jury in real time as the trial is going on, allowing them to potentially shape their ongoing examinations of their witnesses. And so, Your Honor, for that reason, we believe that we're making a motion for a mistrial.
Can I just move?
Yes, sir.
Judge, with respect to the issue with number 33, announcing this question to the panel, I share the defense's concerns about that. It sounds to me like the question almost suggested to them that they should be confused about it and started them reasoning over the evidence. So I share their concerns about 33. I don't share the concerns about 38 that were mentioned because I can't change what my evidence is based on what they asked. Like I couldn't suddenly admit a 911 call because no 911 call was provided in discovery. Wouldn't be allowed to do that, for example. However, and while I know number 38, I feel like number 38 has, begun to form conclusions in her mind about the case as well. And given that, I think I have to agree with the defense's motion.
I will recess to consider this. Again, we also have two alternates. So we could release jurors 33 and 38 and still have 12 jurors. But I do understand your concern that, again, let's parse this up. Jurors 38 were her questions alone and were not shared or disseminated with the other parties. So if there are concerns about juror 38's questions, juror 38 could be released as an alternate, and we still have a constitutional jury panel. Juror 33 did ask his questions of the other jurors, and we're all grateful the other jurors didn't respond and follow the cautionary instructions that the court did give not to deliberate until this case is given to you for deliberation. And now, let me add to this. The sheriff has indicated juror 33, the gentleman does have a notepad back there that was not a notepad court issued, but we don't know what's in the notepad. Let's bring him back out again and see what's in the notepad. Well, hold on, Sheriff. Yes, Mr. T.
Just for the record, regarding juror number 33, his testimony, from what I recall, was not that they did not answer him. He's saying that they didn't have.
Oh, they said, yeah, you're right. They didn't know.
Right.
The answer.
So there's, to me, that indicates.
So let's follow up on that. Okay, bring out juror number 33 again, please. Okay, and you can have a seat, juror number 33.
Thank you, ma'am.
Okay, we, two questions of clarification.
Absolutely.
I do understand you said you asked your questions of the other jurors, and if you could give me the detailed verbatim responses you received, whether it was they did not answer you or they said words, if you could give me the actual, your recollection of those conversations, and with how many jurors?
My recollection of the conversation was when I posed the question, our officer here, and he said he could not answer it, would present it to you.
And you posed questions to who? Oh, okay, gotcha, the chair, okay?
Yes.
And he said he could not answer.
Could not answer that as a question for the judge. When he stepped out, I said, I'm just curious about making sure that our information is accurate. Trying to remember verbatim the responses, but generally it was just I apologize, I did not try to log it in my memory. I don't remember any particular responses as much as that might be good to clarify, or be good to know. And the conversation moved on, I believe, to traffic cameras. So I believe that was the extent of the conversation. I'm sorry, I can't be more
So
specific.
your memory is fine, and, so did anybody, were there responses, or did they greet you with silence? Did you receive responses to the question?
The only responses I can recall to any extent was a general assent that clarification would be good to have.
Okay, and how was that general consent, that clarification would be good to have conveyed to you? Was it a physical gesture? Was it
I
a
would
verbal?
say verbal responses to the extent of something to the effect of, oh yeah, that would be pretty good.
Okay, and do you know how many would have shared that? If you can approximate.
Maybe 3 or 4 people at most.
Okay, and those are my questions for you, but again, as procedure, I'm going to turn to the attorneys and see if they have additional questions.
So you just sort of in passing mentioned that the conversation moved on to traffic cameras.
Yes.
Is that right? Was it like, could you describe the nature of what that conversation was?
Trying to remember, because it was going between considering my question, sipping my coffee, and generally paying attention to traffic. So I apologize if this is not totally specific. We're trying very hard to not discuss the case in any capacity, and so we're finding other topics of conversation. People were discussing kind of been clocked by traffic cameras.
Okay,
and
so
that type of thing.
sure. So it wasn't in relation to is there traffic camera evidence in going
Oh,
to be
no,
shown in
not at
this
all,
case?
sir.
Okay.
No.
Oh, I don't have anything for
Okay, Mr. Rogers and Mr. T?
Yeah,
Okay, no additional question. Okay, and then juror number 33, it was mentioned to me that you had an extra notebook. Are you recording any notes from the trial in that extra notebook?
The extra notebook was the initial notebook I brought in. I was unsure if notebooks would be provided to us. I left it here with the other one. I believe it just simply says jury notes and the date. And when I heard that we were not allowed to take other notes, the notebook was placed down at my feet and has not moved from that position.
Wonderful. Thank you.
If you'd like to have
Again,
that.
let me, because I changed the topic, let me turn to the attorneys and make sure they don't have any additional questions.
None from the Commonwealth.
Okay, thank you, juror number 33. And again, you are not in trouble, but we just have to make sure everything is perfect.
I understand.
Before that, you can retire back to the jury room. Thank you very much.
Thank you, ma'am. Thank you.
Okay, anything additional before I take a recess to research and consider the issue? The mistrial motion made based upon juror number 33 having conversations with the other jurors.
My position remains the same. No,
Yeah, our position remains the same, and just want to note that the juror seems to not remember, not remember exact conversations that went on regarding the issue.
So again, I'm going to retire for deliberations. Just for human planning purposes, it'll probably be at least 15 minutes. So if people need to use the restroom or go to the car or something, please feel free to do so. I'll be honest, I'm inclined to deny the motion, even though both parties have made it. As the question for clarification, did you understand that? And responses, I think will be harmless, but let me research it and consider it in detail. And I'll be back in, let me see, it's 9:54. Let's try to check in at 10:15. And then, Madam Mayor will make sure jurors have, extra snacks and whatever they need, because they've been in that room a good hour and 15 minutes by that time. Okay, I will be in recess. Thank you.
All rise.
to the moving party. The burden of establishing this probability of prejudice lies with the party seeking the mistrial. The standard is abuse of discretion, and to succeed on a motion for mistrial, the moving party must demonstrate a manifest probability that the misconduct is prejudicial. The allegations of juror misconduct arise, or if, the allegations of juror misconduct arise, the trial court may be required to investigate the matter to determine whether the prejudice occurred. In this case, the defense, which is the moving party, has not established a manifest probability of prejudice. The court did investigate the juror misconduct. Again, Virginia courts have delineated between misconduct inside the jury room and outside of the jury room. In this case, this would have been not outside, such as unauthorized communications with third parties or introduction of extraneous evidence, but it was misconduct confined to inside the jury room, specifically premature discussions among jurors. And case law has indicated that that is less likely to result in a mistrial unless it demonstrably affects the fairness of the trial. And in this instance, juror number 33 had questions about procedure of the jurors, not questions of fact. And I also want to make that distinction here. In addition, Virginia statute does provide a mechanism for addressing juror misconduct. And that is 19.2-262.01. So in summary, the misconduct here was not prejudicial, or is not prejudicial as found by the court legal decision. And a curative instruction can be given, and I will again bring them out and tell them that they are not to discuss the case, ask questions of each other about the case until it is submitted to them for deliberation. The case law that the court is relying on is Robertson versus Metropolitan Washington Airport Authority, Reiner versus Commonwealth, Caterpillar Tractor Company versus Holvey, and Day versus Commonwealth, in addition to the statute cited. All right, so with that being said, motion is denied and we're ready to move forward. Can we bring the jurors out?
Judge, I understand that the defense has an objection to the authentication of the video that the court has already considered, and that objection is going to require me to lay a foundation by showing her the video and asking her to authenticate it.
Okay, so we want to do that outside of the presence of the juror.
I think so, and to hear her both sides.
Mr. Rogers.
That is correct, Your Honor. Instead of bringing them out, then having to exclude them again, so we could lay the foundation and authenticate the video. I think it's for judicial time, we should just go ahead and bring her out, authenticate the video, and if the court believes that the authentication is proper, go ahead and present that to the jury. I do have another concern. That is, at the beginning of the trial, the court ordered that all witnesses be sequestered back in the witness rooms. I think there's at least 3 rooms, and I think there's multiple witnesses in each room concerning that they may be discussing the case, may have heard about the evidence that has been presented in the case, and may be discussing that. And so I'm concerned that the court's ruling on sequestering the witnesses may have been violated, and it's being violated.
Okay, and again, I believe there are over 20 witnesses in this case, and we don't have the physical space to give them their own separate rooms. But of course, they are sequestered, and it's on the attorneys to identify them and to instruct their subpoena witnesses as to the rules. Do you have a basis for believing that they may have discussed the case?
No, I'm just believing that's a probability, of course.
Probability just because they're sitting in the same room.
And they're talking, but of course I'm not in there. I don't know what they're speaking about.
All right, without more specific information, that the court is going to deny your motion, but feel free to voir dire them regarding that when they take the stand. Okay. And the Commonwealth's witness that we're going to pre-clear the testimony or evidence.
Yes, Your Honor, Nina Farish, Dr. Farish.
Okay, bring out Nina Farish, please.
Raise your right hand. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Okay. Then you take the witness stand, please, and watch your step. There's a stair, and the chair and microphone are adjustable. And, Ms. Ferris, we're gonna take up some of your testimony outside of the presence of the jury to deal with any objections and evidentiary issues. And depending upon the ruling, we might bring the jurors out, and then redo it. So I just want to explain to you procedurally what's happening right now. Okay. If the attorneys have any questions, we'll start with Tom. Yes, Ms. Rogers?
Well, before the video is played, I would like for it to occur during the video prior to her actually viewing it.
Okay, and I don't know what order Mr. Jenkins is going into. Do you want to start with the questions, Mr. Rogers?
Judge, may I propose that I lay an authentication foundation, not play the video, let the defense counsel voir dire as appropriate, and then the court will rule whether she can watch the video to authenticate it.
Okay. Yes, please proceed.
Good morning. Could you please tell us your name and how you're employed?
Nina Farish, Human Resources Director with Newport Public Schools.
Were you employed in that same capacity in January of 2023?
Yes,
And as part of your official duties as the HR director, were you required to conduct an internal investigation into the shooting at Richneck Elementary School that occurred on January 6, 2023?
yes,
As part of your investigation, did you have occasion to interview numerous people?
yes.
And technically, how did you conduct the interviews?
The majority of them I did via Zoom,
Okay.
recorded.
And did you conduct an interview with someone named Dr. Ebony Parker?
Yes,
And what was, prior to January 6, 2023, what was Dr. Parker's title with Newport News Public Schools?
assistant principal.
Okay. And do you see Dr. Parker in the room right now?
Yes,
Could you please just point her out for the judge?
same.
I'd ask the court to recognize she's indicated the defendant.
So noted.
You've indicated I'll ask it again because I'm not sure what your answer was, but did you do an interview with Dr. Ebony Parker?
Yes,
All right. And was that was that interview conducted in person on Zoom or some other way?
via Zoom.
Okay. If you were shown that video or clips from that video, do you believe you would be able to recognize it as the one you created?
Yes,
Okay, thank you. For now, I don't have any other questions for you, but defense counsel, I think that's.
Good morning, how are you?
good morning. Fine.
Great. So regarding any video that was produced, did you keep, or were you the sole custodian of that Zoom video?
Yes,
Okay, and where was that video maintained?
on my computer,
Okay. Did anybody else have access to your computer or was it just you?
just me.
Okay. Did you provide a copy of the video to anyone?
Yes, when asked by the attorneys.
When you say the attorneys, what attorneys?
The ones that represented the school district.
Okay. Did you provide a copy of that video to Mr. Jenkins, the Commonwealth?
No, I'm trying to remember the name of the law firm because as I recall,
So the civil
Mr.
attorneys,
Jenkins was not the original attorneys.
the civil attorneys?
Correct.
Okay. So had you gotten a chance to review the video that's in the possession of the Commonwealth?
Yes,
When did you review that video?
I reviewed the copy that I still have, and I reviewed it to refresh my memory.
Okay, I want to make sure that you understand my question.
Okay.
A copy of the video that the Commonwealth has, have you reviewed that?
I'm not sure how to answer that question because if I didn't give it to the Commonwealth, I don't know which video then you're referencing.
That's right. So you did not personally give the Commonwealth attorney a copy of the video,
No.
and you're not sure that the video that the Commonwealth has is an accurate copy. Is that correct?
That's correct.
Okay. So the video that the Commonwealth has, you don't know if it's actually been altered. Is that correct?
That's correct.
Okay. So you don't know how many hands that video has gone through before it actually came into possession of the Commonwealth. Is that correct?
Correct.
Okay. So you really can't verify the accuracy of the Commonwealth's video.
Correct.
Can I have a moment now?
Yes, sir.
Okay, and this recorded video, is it stored in your office, or is it stored in the cloud someplace, or is it stored on Zoom's the Zoom app, or how is it actually how is it preserved?
It's on my laptop.
Okay, so you actually have a copy of it on your laptop.
I would call it the original because I've never, except when subpoenaed, made a copy.
Okay. And again, you provided that to the civil attorneys, but not to the Commonwealth.
Correct.
Thank you. I'll tell you what, let me just take a second.
Good morning, Ms. Ferris. Regarding the video that you're saying that you recorded, did you record it or did the Zoom platform record it?
Well, I pressed record, but it was the Zoom platform that's recorded on.
Okay, so you did not actually record it with your own device or anything like that?
No,
And so the actual video was something that you downloaded from Zoom or was provided to you later via Zoom, correct?
repeat that question.
You said, I believe the testimony is that Zoom recorded it. You pressed record on the Zoom platform
Correct.
and Zoom recorded it.
Yes.
And then you were able to, I'm assuming, download it in some way, or how did you get it onto your computer?
I have the Zoom app, so then I just reopen the recording
Mhm.
and it can play for me.
Okay, thank you.
Okay, in one moment, Dr. Parrish, any further questions, Claudia, before we? Okay, your arguments were towards the video?
Your Honor, she testified that she cannot verify the accuracy of the video that Commonwealth has. She hasn't viewed it. She testified that she cannot verify that whatever video the Commonwealth has not been altered in some way. There's all sorts of ways to manipulate a video. It could be run through artificial intelligence and alter. She testified that she can't. She's not in a position to be able to verify.
Do I have permission to play the video?
Yes. And Ms. Rogers, did you want to say something?
Your Honor, what I don't want to happen is that she's already testified that she cannot verify a video that's in possession of the Commonwealth is accurate. So what I don't want to happen is for her to see the video and just sign off on it without actually having it examined ahead of time to determine its accuracy.
Judge, if I may.
You may.
The two things I need to say about this. One, the video I'm going to show consists of 3 clips that I intend to admit from a larger video that defense counsel received in discovery back in November. So it has been altered in the sense that I'm only showing the parts that I seek to admit into evidence. Also, it has been altered to mute the name of JT. But if we want to use the original, I have no objection to that. It's just longer and contains what I believe to be pretty irrelevant, but I wouldn't object to it. I'm happy to show it to her now, and we will see whether she recognizes it as being clips of the interview that she conducted.
All right, and the 3 clips, are you able to give me a duration of each clip?
Because they are in one file,
And if you can't, that's fine. I just didn't know if you can.
the total duration of the 3 is, let me make sure before I say.
You're on the line.
16 minutes and 36 seconds is the total duration.
Okay, thank you, Mr. Jenkins. Yes, Ms. Rogers?
Counsel has already admitted that the video has been altered. So with that admission, she can't vindicate it. There's been, counsel would say minor alterations. But Your Honor, I'm not comfortable with just presenting clips. She needs to vindicate the whole video, and if part of it comes in,
Okay. Do you have any authority for that position, Mr. Rogers? I'm unaware of the authority that, if she is able to say that this is an accurate, fair and accurate representation of the interview she conducted, what authority indicates that it can't be redacted to the relevant parts and that you cannot mute sensitive information such as the names of minors involved? What authority do you have for that makes it inadmissible?
No, I don't have any authority regarding the muting or the name of a minor, but I'll just cite Reyes versus Commonwealth. And I've got a copy of it before.
And regarding clips, 3 clips versus the entire video.
It doesn't directly address that. Yeah, it doesn't.
Okay,
Just-
but the other thing, you're saying, if they get parts, I want the whole one. How do you wish to do that?
Your Honor, I'm going to object to just a part of it because of the reports of context. If some of it comes in, Rudy's entitled to it.
And Commonwealth, if they're not objecting to that. So what I'm asking you is, how do you want that? And well, let me back, Mr. Jenkins, how long is the entire interview?
I'll have to look at
Because
that.
that's what I'm asking Mr. Rogers, are you asking that we play the entire interview?
Yes, essentially.
Okay, that's all, how long is the interview?
The whole video is 28 minutes and 58 seconds, I show. Let's see.
Okay, that's fine, okay. So we will play the whole video for the jury, should it meet the other identification things. Anything else, Mr. Rogers? Okay, so Mr. Jenkins, what are you prepared to play, now for the witness?
Well, I can play the whole video if that's what it's going to take to authenticate it. If defense counsel would agree to let me show her a freeze frame and verify, we can do it that way.
Mr. Rogers?
So I'm going to ask that she be shown the entire video, but then when it comes down to the presentation of
I think I understand that the defense is wanting to admit the entire video into evidence on a disc so that the jury could see the whole unedited, unredacted video and only play for the jury the clips, the 3 clips with the redactions in place. And if that is what the defense is suggesting, I do agree to do that. I think that's fine.
If the court feels that, it has been properly.
Okay, all right, so, we agree to proceed in that manner, except she doesn't need to watch the entire thing. Ms. Perry, she's gonna show you portions of the video and ask you questions about it. But in terms of the entire video, if at any point you say that that's not accurate, please let us know. But I'm.
Your Honor,
Yes, Mr. Speaker.
just before we start, I would note that, Mr. Commonwealth has indicated that, all of the 3 clips have been melded into one file. So they've been joined together, which I think, obviously wouldn't make it mean that it jumps from clip to clip without the context in between. So I do believe that there may be some issues with playing just those 3 clips, especially if they're in one melded video that's, combined into one file. I don't think that would be, fair to Dr. Parker, because it would leave out, I'm assuming that he's jumping, I haven't seen this video, the spliced one, he jumps, he's saying that he's joined 3 clips together into one file that plays continuously.
Okay, well, let me hear from Ms. Jim.
Judge, the 3 clips that I'm playing are melded together, so to speak, as defense counsel says. But I am happy to tell the jury, and I'm sure Your Honor may as well, that I am showing clips and that they will have in evidence the full unedited, unredacted video. And the jury can know that up front, and I see no problem with that.
Okay, and to the 3 clips, because they're spliced. In between the splicing, is it obvious on the video that this is a splice and we're going to jump forward in time and hear another portion and then we're going to jump forward in time?
It makes a small jitter or jump, it is all, but it doesn't, fade to black and come back up.
Okay, so there's some kind of visual signal that something is happening.
Admittedly, you have to be kind of watching closely because it just jitters, the people move oddly, and that's when the new clip starts.
Understood. Okay, so what is the defense motion? Because Mr. Rogers said it's okay to play it, but as long as they get the entire video for deliberations, Mr. Teague is saying play the entire video. We're talking about 12 extra minutes.
Yes, Your Honor, I think that, that's an alteration that goes beyond using people's names and clicking, making splices that are obvious to the jury. I just don't think that should be played.
Given that, Judge, here, I am offering that into evidence. That is what I'm offering, the clips. And the counsel is free to offer whatever they'd like. They have a copy of it.
No, we don't agree to admitting a spliced, altered video into evidence. We just don't.
Okay, give me the authority that indicates that that's not admissible. I'm not aware of it. And Mr. Rogers, what case law has you made it up?
This is, Commonwealth, Supreme Court of Virginia, December 19th of 2024. And so I will begin. It's not case numbers, but the rules begins at, you'll see, February 1819. That's probably verified by the testimony of the witness as fairly representing what the witness has observed is admissible in evidence, and it need not be proved by the individual who made it. And then I'm just gonna go on down. It says that the silent witness or a witness that speaks for itself, video or photograph evidence is admissible when given an adequate foundation ensuring the accuracy of the process producing it. Obviously, this splicing was not something that she's going to be able to verify the accuracy. And so, going down to paragraph 22, 23, it's the second sentence. It says, focusing the authentication required on one discrete moment is too narrow to bear on the genuineness of the video as a whole. And then going down to paragraph 24, it says, for a witness to affirm that the video accurately in terms of the video, which is not necessarily a witness to be able to testify every moment, rather than sufficient for a witness to affirm the video accurately represents what transpired based on the witness's observation. So, Commonwealth has admitted that this video in its form as it's been altered. Obviously, the Commonwealth is going to be presenting video that points more to Dr. Parker's guilt than innocence. So, in its form, it's highly prejudicial to Dr. Parker. We also believe that just those clips should be presented as Commonwealth has the circuit prepared. Obviously, Ms. Farage has not seen the clips in their form, and so she can't verify the process of how even these clips were produced.
Judge, would you like me to respond?
No, sir. So the court is going to allow the Commonwealth to play the 16-minute clips of what the relevant portions are to the Commonwealth in their perspective. Again, the evidentiary rules are about reliability. Is the thing what it purports to be as proclaimed by the proponent? Are the legal principles involved? And is it a fair and accurate representation? Once those are satisfied, it comes in. I note the defense's exception. Mr. Rogers also brought in the word prejudicial. I don't think he's laid an adequate basis for why this is prejudicial. So you may proceed with your attempt to authenticate this, and then we can get moving with the jury trial.
Okay, Your Honor, given the court's ruling, the video that I'm about to play is the video that the Commonwealth would seek to admit into evidence that has the three different clips.
Yes, sir.
Your Honor, before we go, so there was discussion about if the video is admitted, presenting the complete unredacted copy to the jury. Was that
Is that still a defense request? And Commonwealth is in agreement with that?
Yes.
We're just talking about the parts that you all were not able to reach an agreement.
Okay.
Okay. All right. Yes, sir. You may proceed.
Thank you, Judge.
So Dr. Parker, thank you so much for joining me today. I'm here to first ask if you are giving permission for me to record this session to discuss the incident that occurred at Richneck on Friday.
Yes.
Okay. So as part,
If I may, Judge, ask the witness, does what I've shown so far appear to be the interview that we've talked about?
Yes.
Judge, I can keep playing a little more, or I believe she's laid a foundation that this is the interview.
Mr. Rogers?
Your Honor, she's only seen my client's face. She's certified that I just want to ask it for purposes of identification. There's no way she can verify that what's on this 16-minute clip is accurate. She has to see it.
Ms. James, if you just jump to two other sections, if you're able to, and play about 10 seconds and ask the same questions.
Okay, I can.
Let me see.
Oh,
Oh, sorry. I'm seeing at the bottom of this screen a date and time stamp, and those are military hours. So those will move as you move your cursor?
Yes,
Okay.
Your Honor. So I can make a record of those.
Okay, and I didn't know if that's on the video, or if you have another cursor mark on your laptop that's showing the different timestamps.
So I have on the laptop, it is in absolute time, meaning 0 to the end of the video. But what I believe is on here is in the date and time it was
Oh,
recorded.
understood. Okay, yes, please. Okay, proceed. Thank you.
So I'll resume playing the video from 15:38:28.
And he left. But those were the only two.
Okay, so help me understand.
And Dr. Ferris, does this still seem to be your interview with Dr. Parker?
Yes.
I'll jump forward a bit more. I've now jumped ahead to 15:47:26, and I'll play from there.
I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay, all right. So just to be clear,
And Dr. Farish, same question. Does this still appear to be portions of your interview with Dr. Parker?
Yes.
Judge, with that, I think we've laid a sufficient foundation for authentication purposes for this video.
Yes, sir. Anything additional from the?
No, just to try to stress the whole point of authentication is to verify accuracy. This is going to be the first time that she's going to see these clips as the Commonwealth has prepared them. We don't know what type of manipulation has occurred from. She didn't give this record to the Commonwealth. She gave it to other attorneys. We don't know what kind of manipulation occurred in the possession of those other attorneys or the IT professionals, any other person between the chain from first, the other attorneys in the Commonwealth. Just showing her those very few seconds, she's not verifying the accuracy. She's verifying that essentially that's her talking to Dr. Parker. That's it. She's not verifying the accuracy of the contents of that.
Okay, so again, the defense will continue to note their objection for the record. The court, again, is going to allow this video to be played to the jury for the rulings it's previously made. But again, the defense exception is noted.
Judge, may I please request to make a quick record related
You
to
can, I'll
that?
let you make the record.
Thank you.
But the court is also going to give a cautionary instruction to the witness. At any point when this is played, if you see something that is not accurate, please immediately say so we can address the matter.
Yes, ma'am.
All right, thank you. Yes, Mr. Jenkins.
I just want to quickly, in response to, for the purposes of the record, Rule 2901, requirement of authentication. The requirement of authentication is satisfied by evidence sufficient to support a finding that the thing in question is what the proponent claims. It is not about accuracy. It's about is what it claims. The arguments counsel has made about chain of custody and accuracy of the video, those go to weight, and he is free to make those arguments to the jury. They don't go to admissibility. Thank you for allowing me to do that, Judge. I think we're ready for the jury.
All right, Sheriff, if you kindly bring the jury out, and we do ask all parties to stand while the jury comes out. If you're able, if they're able.
Your Honor, I'm going to step out.
Okay, step out, Mr. Rush. Yes, sir. We'll wait till you come back. I'm sorry, everybody. Get your knees in your back stretch. Yeah, it's a good stretch break. Let's stretch. Here we go. place, and we will bring the jury out. Thank you, Sheriff. And again, okay, let's practice again. Let's all stand. Let me stretch.
Same seats. 14 jurors in the box, George.
Thank you so much. Everyone will take their seats, please. As your head count. 14 jurors are in the box. Happy Wednesday to everyone. Thank you for the time. This morning, we've been there for about 2 hours while we were working on some motions to hopefully keep a swift pace through the day. As usual, we'll try to break around 1 and try to include around 5 for evidence for the day. And if you need any breaks, let me know. Now, I haven't asked the parties, the juror box as a whole, but we have that cautionary instruction not to research this case outside of what's presented to you in the courtroom, not to discuss it with others, and if somebody approaches you, to inform the court. Does anyone wish to report any potential misconduct or issues? Okay, and there is nothing being said, and for the record purposes, parties are shaking their head in the negative. And again, I'll give another cautionary instruction, again, amongst yourselves. Please do not discuss the case or ask questions until this case is given to you for deliberation. That's a specific legal moment and legal procedure. You can talk about the weather, talk about family, but just don't talk about the case or questions amongst yourselves until the case is given to you for deliberations in that moment. Okay, with that being said, we are going to proceed with evidence today. The witness has already been sworn in, and the Commonwealth will start the direct examination. Mr. Jenkins.
Thank you, Your Honor.
Good morning again.
Good morning.
Would you please tell us your name and how you're employed?
Nina Farish, Human Resources Director for Newport News Public Schools.
And Dr. Parrish, how long have you been in that role?
For 4 going on 5 years.
And so were you in that role on January 6, 2023, and in the month of January 2023?
Yes.
Do you know someone named Dr. Ebony Parker?
Yes.
And was she employed by the school system?
Yes.
How so?
As an assistant principal.
Okay. And is she in the courtroom right now?
Yes.
Could you please point her out?
Yes.
And Judge, I'd ask the record reflect that she's identified the defendant.
So noted.
After, did you become aware of an incident occurring at Richneck Elementary on January 6, 2023?
Yes.
And after that incident, were you called upon to investigate it?
Yes.
Generally, what was the nature of the incident you were told to investigate?
A student shooting at Richneck Elementary School.
Understood. As part of your investigation, did you conduct interviews with many people?
Yes.
Did you conduct an interview with Dr. Ebony Parker?
Yes.
And technically, how was the interview done?
Via Zoom recorded.
Okay. If I were to show you different clips that have been edited of that interview, would you be able to recognize those clips as being the interview that you did?
Yes.
Okay. Judge, with the court's permission, I'll publish this to the jury and indicate as well that this is 3 clips from a larger video that we will enter into evidence as well, and that the audio on this has been muted wherever a child's name was spoken. May I publish to the jury?
You may, and for the jury, defense has objected, and of course allowed that the video will be played. whether the attorneys want the courtroom to be dimmed.
Not necessarily.
Okay, you may proceed.
Okay. So Dr. Parker, thank you so much for joining me today. I am here to first ask if you are giving permission for me to record this session to discuss the incident that occurred at Richneck on Friday.
Yes.
Okay. So as part of our internal investigation, I have some questions for you. I do ask that you please answer questions honestly. I also ask that you please keep our investigative conversation confidential so that to maintain the integrity of the investigation, because I do have several people I need to speak with. Okay? Okay. So, Dr. Parker, let's start with Friday. Were you given any knowledge prior to the actual shooting that the student had a weapon?
I was told that students reported that the student had a weapon in his backpack.
Do you
So,
go ahead.
So, Ms. Kodak, what would I use his name, sorry?
Yes, ma'am, please.
Okay, so Ms. Kodak was the one who informed me of this. And she said that she had already asked the student, is there something in the backpack? And he said no, but she had brought it to me. The class was about to go outside to recess. So I said, well, when they go outside to recess, we can check his backpack. I was in the midst of the winter growth assessment, printing off tickets and such. So I didn't go into the classroom with her. When she came back, she says, there's nothing, I didn't see anything in his backpack. And I said, okay. And she says, but, what about in his pocket? And I said, well, I don't know. Are they going out to recess? She said, yes. She was also my person that was helping me with testing. So, I don't know if she went outside or not, but there was a comment that said, we watched him closely. Assuming she meant herself and the teacher. And I said, okay. And then I went on with testing.
So was all of that conversation from Ms. Kovac all at the same time, or did she come back to you with the comment about we watching him?
She came back.
Okay. So, do you remember approximately what time it was when she reported to you, the students reported that he had a weapon?
They were going outside for recess at 12:20, so it was right before that. So I don't know how far between that, but I know from the time that she said it to the time that they went outside for recess, it wasn't very long.
Okay. Did you report this to Ms. Foster?
I did not. She was in a meeting with a military counselor that we were supposed to be getting, and I was supposed to be going into that meeting at 1. The meeting was at 1, and I didn't make it into that meeting. But because I was in the midst of testing, I don't leave my office when we're in testing to maintain, the testing tickets and the security of that. And so I had not spoken with Ms. Foster.
Okay. So can you tell me, did anyone else come to you before the shooting to tell you that the student had a weapon?
So, after we checked his backpack and there was nothing there.
And you say we?
Well, I say we because I said check it. So, but Ms. Kovac went in to check it.
Okay.
Yes.
Okay.
But I said we because she came to me to ask, should we check his backpack? Did we check his backpack? Mr. Rawls, after that situation was settled, came back into my office and he said, hey, did you hear what they said about? I said, yeah, I heard. I said, but we checked his backpack. And again, I'm still using we, but it was Ms. Kovac. I said, his backpack was checked. We didn't see anything. And he says, oh, okay, did you check the person? And I said, ooh, no, we didn't. And I remember looking at the clock and it was 1:40. And this particular student is on a modified schedule. So I said, his mom is due to come here soon. So when his mom comes, we need to inform her of what was said, what we did, and she can, we'll let her go through the rest of his things and check. The students need to inform her of what was said, what we did, and she can, we'll let her go through the rest of his things and check it. He nodded his head and he left. But those were the only, it to look in the backpack. But we never searched a student. So because we didn't, Ms. Clark didn't see anything in the backpack, then we didn't do anything from there. His mother does come in every day and we have a conversation every day. So I was waiting for mom to come in.
So in the past protocols of what you've done, and correct me if I'm wrong, you've brought the student into your office and you, along with who else?
So the first time it was Mr. Rawls, and then the second time it was an incident of a parent had already called the police because the report was given to her from her son, so she had already called the police. So the second time it was the police was at the school.
Okay, all right. Had Mr. Zwerner on that Friday come to you and express concern about the student, about the student's behavior, or did she express that she thought the student had a weapon?
No. So Ms. Zwerner never said that she thought that the student had a weapon, and she never said to me directly that it was reported to her that the student had a weapon. So I was about to get the PM session of the testing started, and she came into my office and she said, is being extremely defiant today. And she says, if he hits me, I don't know what I'm going to do. So I acknowledged what she said, and I said, oh, okay, and then she left. So I told Ms. Kovac, because they didn't want to look bad at the kids, I said, if she feels that he's being, uncontrollable, she can't control him, tell her to call his mother so she can come and pick him up early, is what I said. But no, Ms. Zwerner never came to me and said anything about her fearing that the student had a weapon or that she felt unsafe. She didn't say that to me.
Okay, all right, take your time. Had Ms. Zwerner, prior to Friday, ever expressed to you that she had concerns or felt unsafe with this particular student?
So has been on a modified schedule since the beginning of the year. His acting out was he's extremely defiant. And he does the exact opposite of what he's asked to do. And it was making it difficult for her to do instruction in the classroom. So we sat down and we made a modified schedule. We had things in place, so somebody was getting the bus. He was going to Miss McBurnett's room to do a social story. He was then transitioned to Miss Kovac for a 15-20-minute small group session before he spent time in his classroom. And Wednesday, he had asked to come to the office, and he said no. Ms. Zwerner said no, he couldn't come to the office. And he took her phone and threw it down. So it cracked her screen. Ms. Foster and myself, I sat in the meeting, but Ms. Foster had, facilitated the meeting that afternoon with Ms. We told, hey, no damage that it is to the teacher's phone, we'll let you know. She understood that she was prepared to pay for it and everything. So, in hindsight, that evening, I spoke with Ms. Foster, and she said, I really think I'm gonna call mom back because he should have gotten a consequence for what he did. And I said, well, yeah, but I was following her. So I said, okay, she called back, was not in school Thursday. And then when he came back Friday, those were the events of Friday.
Okay, all right. So just to be clear, at any point in time prior to Friday, did Ms. Warner ever report to you that she had concerns about the student or about her safety with that student?
No. The concerns were around the student and his behavior. Never has she said, I feel unsafe.
So when she made the statement to you, if he hits me, I don't know what I'm going to do. Can you tell me where that came from?
So that Wednesday, where I feel it came from was that Wednesday when he took her phone and threw it down, he went to a buddy classroom, which was Miss West. And what Miss West reported to Miss Newton was that he was pinching at her, but I did not get I didn't get the full report of that incident. So when she said that, me knowing that was what was reported Wednesday, that's where I think that came from.
Okay. Was there ever a comment made to the teacher that she was overreacting to the student or his behavior?
No.
Okay. Prior to Friday, had anyone, Ms. Zwerner or anyone reported to you their concerns about the student or about their safety or possible safety of others in the building because of that student? Okay. So staff stating that administration made, what is your response to that?
Yes, you can pause. Yes, sir.
Just a moment, Councilman, we have an objection.
A brief moment.
Ferris, things that other people may have said. And so I understand the video is coming in, and it should come in regarding my client's statements. But any statements made by Ms. Ferris, according to Ms. Wilder say, any statements that she is alleging was made or declared by another party, I would submit is hearsay. I would ask the court to instruct the jury not to consider statements of Ms. Ferris or what somebody else may have said, but only consider my client's responses to this question.
Judge, I would ask that we continue playing the video for now and make a decision about whether there needs to be some sort of kit of instruction after that.
So I will, again, continue to play the video, but I will grant the judge's motion that will give a curative instruction. So we'll prepare that when it's time for instructions of whose testimony they can consider from this video and the hearsay. All right, you may proceed, Mr. Jennings.
Judge, may I back up just a little bit to give context?
Yes, sir.
I'm going to start back at 15 hours, 50 minutes, and 0 seconds.
Yes, sir.
Administration knew. What is your response to that?
I don't know. I don't know because what I did and what we did in the moment with how to support with him is what I thought the teachers, Ms. Zwerner, was asking for. Like, just, I can't get instruction done. He doesn't sit down in his space. He won't follow directions. Those were the things that Ms. Zwerner were reporting to me.
Okay. I want to go back real quick because I want to make sure I'm clear on something. Ms. Kovac, check the bag. What is Ms. Kovac's title?
She's our reading specialist.
So help me understand why Ms. Kovac why did you direct Ms. Kovac to check the bag?
So in the midst of testing, I don't remove myself from the office. And when the conversation we had was, should we check his bag? And the reason why we waited till they went out to recess is because I couldn't leave to go and check the bag. So it was my director that said, Ms. Kovac, when they go out to recess, check his bag.
Okay. Did you talk to your resource officer that day?
She was not there.
Okay.
The resource officer, the actual, I didn't call, I didn't call. And our security officer, Ms. Lee, she leaves every day at 2 o'clock.
She leaves at 2, so Ms. Lee was.
I'm sorry, not 2 o'clock, 12 o'clock. And she comes back after McIntosh's dismissal for our dismissal. So she's with us in the morning from 9 to 12. I'm sorry.
Okay. Okay. All right.
Dr. Parrish, was what you just watched a fair and accurate depiction of some clips of a longer interview that you did with Dr. Parker?
Yes.
Judge, at this time, I would seek to admit into evidence a USB thumb drive and an envelope labeled HR Interview Parker that contains the clips that have just been shown to the jury. I would move to enter that as Commonwealth's 2.
I so introduce over defense's previous objections, which were made contemporaneously to be marked as Commonwealth 2.
And Judge, at some point I will need to take a moment to get the full and complete video saved to a drive. And at that time, I will move the full video into evidence as well so that the jury will have access to it.
Yes, sir. Any additional questions for this witness from the Commonwealth?
Yes, Your Honor. Dr. Farish, do you serve as a custodian of records for the purpose of providing things pursuant to a subpoena?
Yes,
And you do that for the school district?
yes, sir.
Okay. And I want to direct your attention to any publications that the district makes that are official. Is there a rights and responsibilities handbook?
Yes,
And is there one in particular that contains a student code of conduct and also is for the year that was applicable, the 2022-23 school year?
yes,
Do you have that document with you today on the stand?
I do.
Would you mind pulling it out? And did you bring that with you today?
Yes,
Okay. I'd like to direct your attention to that document. And specifically, if you would look on page 28 of that document, let me know when you're there.
I'm there.
I'm going to just direct your attention to a paragraph that begins principals and school. Do you see that paragraph?
Yes.
I'd like to ask you to read just that paragraph into the record, please.
Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles.
Okay.
One moment. Yes, what's the objection?
Lack of foundation, Your Honor. Ms. Ferris is not the author of this document. She has not established that she has authored it or was otherwise familiar with it. She testifies that she responds to subpoenas and things of that nature, but she has not made that the proper foundation has not been made.
The court has already ruled on that. It is
We
a,
ruled on hearsay, but we didn't rule on foundation.
okay. Well, she has testified that on hearsay, we had a ruling that this was a public record. She testified that she is the custodian of records and that what she's reading from is in fact an authentic record of the Newport News Public Schools. She brought it with her here today herself, and that it was in effect on the time in question. So that's all the foundation that is needed for her to tell us the content of that document. It is admissible.
The court rules the proper foundation has been laid. If you would repeat your question of what you asked her to read.
Yes, Your Honor. So thank you, Dr. Ferris. This is page 28, a paragraph that begins, principals and school security officers. Could you read that paragraph, please?
Yes. Principals and school security officers, under the direction of a school administrator, may search students and student property, including automobiles and other vehicles, when there is reasonable suspicion to do so. Students should understand that they have no expectation of privacy to their lockers, personal property, or vehicles allowed to park on school property. Consistent with applicable legal requirements, school division personnel may use search techniques such as metal detectors and use other lawful search techniques.
Thank you. I want to ask you now about a different document. Does the public school system require individual schools within the district to create a multi-hazard crisis and emergency management plan?
Yes.
And during the course of your work, if such a plan is subpoenaed in litigation, are you the custodian of records that would provide it?
Yes.
Do you have with you, or have you brought with you to court here today, the Richneck Elementary Multi-Hazard Crisis and Emergency Management Plan for the 2022-23 school year?
Yes.
And is what you have here today with you a fair and accurate copy of that plan?
Yes.
Okay, please give me just a moment. I'd like to direct your attention to page 18.
Yeah, I'm gonna request some body on this, her foundation of knowledge regarding this particular document.
Okay,
If the voir dire is going to admissibility and it's going to be allowed, we will have to remove the jury from the room. Because admissibility is not a factor for them.
Mr. Dean,
Yes, sir.
and what's the basis for this again?
I don't think a proper foundation has been laid regarding her familiarity with this document itself. Again, he says that she responds to subpoenas and produces it in response to subpoenas. That does not mean that she has familiarity with the document, knowledge of who created it, or anything of that nature.
So I'm not gonna allow this voir dire at this point. Mr. Jenkins, can you try to lay a better foundation?
Okay, Dr. Ferris, let's back up. Is the multi-hazard crisis plan for 2022, 2023 required by law to be created by the schools?
That is my understanding.
Okay, and are the plans records of the schools?
Yes.
Official records?
Yes.
And is what you've brought here today an official record of the school that was in effect at Richneck on 2022, 2023 school year?
Yes.
The foundation's been established, you may proceed, since objection is overruled.
So I'll direct your attention to page 18. Do you see the heading that begins imminent warning signs?
Yes.
18. And also, I want you to just look over to page 19. Do you see the heading that says mitigation?
Yes.
I am going to ask you to read everything between those 2 points, stopping before the mitigation heading.
Okay.
And also, the court reporter is writing this down, so if you could read relatively slowly to make sure.
Your Honor, I'm sorry, I need to do it.
10 seconds.
I'll provide it, Judge.
Thank you. All right, you may proceed.
Unlike early warning signs, imminent warning signs indicate that a student is very close to behaving in a way that is potentially dangerous to self and/or to others. Imminent warning signs require an immediate response. No single warning sign can predict that a dangerous act will occur. Rather, imminent warning signs usually are presented as a sequence of overt, serious, hostile behaviors or threats directed at peers, staff, or other individuals. Usually, imminent warning signs are evident to more than one staff member, as well as to the child's family. Imminent warning signs may include serious physical fighting with peers or family members, severe destruction of property, severe rage for seemingly minor reasons, detailed threats of lethal violence, inappropriate possession and/or use of firearms and other weapons, other self-injurious behaviors or threats of suicide. When warning signs indicate that danger is imminent, safety must always be the first and foremost consideration. Parents should be informed of the concerns immediately. School communities also have the responsibility to seek assistance from appropriate agencies, such as Child and Family Services and Community Mental Health. Immediate intervention by school authorities and law enforcement officers is needed when a child has presented a detailed plan, time, place, method to harm or kill others, particularly if the child has a history of aggression or has attempted to carry out threats in the past. Is carrying a weapon, particularly a firearm, or has threatened to use one, or exhibits other threatening behaviors.
Thank you, Dr. Ferris. I'm going to direct your attention to just one more section of that same document. We're just going to page 60. And on page 60, do you see the heading weapons threat?
Yes.
I'm just going to ask you to read only that section that falls under the heading weapons threat.
If a student or other person makes a threat with or about a weapon, gun, knife, or other weapon, evacuate the area, evaluate the perpetrator, isolate, consider lockdown, notify law enforcement, remain calm, get help, avoid heroics, do not threaten, keep a safe, non-intimidating distance, avoid abrupt, sporadic movements, look for an escape route.
Thank you, Dr. Ferris. That's all the questions that I have for you. Please answer any questions from defense counsel.
You may.
Still morning. Good morning again. All right, a lot to unpack. So just to go over, again, you are the HR director
Yes, sir.
for Newport News Public Schools. And you conducted an independent investigation of this whole incident, is that correct?
That is correct.
Okay. And in your investigation of this whole incident, did you have access to the videos from school property or any other videos that?
Objection. This goes beyond the scope of the direct exam and, is also asking about the investigation and other things that didn't go into.
It was elicited on direct. That's one of the first things that she testified to, is that was her responsibility to do a complete investigation of this incident.
Okay, and that was one part of your question, but there were other parts. So I'm
I
trying
was-
to figure out where the scope objection lies.
So I'm asking her about how she conducted the investigation. I think it's a fair question, then.
And what part was your scope objection towards?
The concern, Judge, is getting into the findings of the investigation, but as to did she conduct an investigation and what did she observe in the investigation, I wouldn't have an objection to that.
I hadn't gotten to the point where I was asking for a conclusion at all.
All right, okay, but if you're planning to get there, I think he's going to object.
Well, we'll see what happens as we go along.
All right, you may proceed.
Okay, so you did conduct a complete investigation of this from the beginning of the incident to the end, is that correct?
Correct.
Okay, and as a part of your investigation, did you do the videos that may have been taken, produced on Newport News School System's surveillance cameras?
Yes,
Okay. Did you also look at videos that may have been produced by Newport News Police Department?
not by the police department, no.
Okay. So could you describe how many different positions video cameras are placed at Richneck Elementary School?
You want me to describe, you're not asking me how many.
I'm asking you how many different positions, sir? Is it?
I don't recall how
Oh,
many.
Okay, well, let me ask you a different question. Would you say that you could pretty much, through this video surveillance, monitor most of the activities that occurred at Richneck Elementary School?
Most, yes.
Okay. Were you able to see what things occurred in the hallways?
Yes.
Objection, Judge, we're getting into the content of things that he's not planning to show. He should be required to produce those videos if he's going to ask her about those videos.
Response?
I don't think I'm required to show anything. She's testifying, she's producing evidence. I don't have to cooperate that by video.
And what objection is this? What legal principle is invoked here?
Lack of foundation.
Your response.
Your Honor, she's testifying as to what she observed. So, she looked at videos, she's testifying as to what she observed on these videos. So I'm not asking to introduce these videos, I'm just asking her what she observed on these videos.
And are you going to ask her to describe what she observed on those videos?
She is probably, I'm going to ask her to summarize what she saw in these videos, yes.
How is that admissible?
How is it admissible is something that she observed. I mean, she can testify as to what she observed.
Okay, so that goes back to his objection. Why isn't the best evidence rule implicated at that point, or other evidentiary rules? I guess what authority exists to allow her to testify as to what she observed in the video without the actual video? And is this video admissible in and of itself? So if the video is not admissible, how can she testify as to what she saw on the video? How would that also be by analogy admissible?
Obviously we have already submitted video into evidence.
Well, one video. Are you talking about that video or a different video?
No, I'm talking about the surveillance video, and I think the court and even the Commonwealth is well aware that videos are considered to be silent witnesses of whatever events that they record. If I had the videos, I can, I guess I can ask the court to take a recess so I can show her several videos that the Commonwealth just released.
Two questions, or I guess one. Yes, she could not testify to what she saw on the video. Second, are you asking to introduce evidence in the Commonwealth's case in chief?
Obviously, evidence is coming in through the Commonwealth's case in chief.
I'm saying, is the defense asking to introduce defense evidence in the Commonwealth's case in chief?
Not at this particular time, other than the testimony, Your Honor.
Okay, so again, my ruling is that she cannot testify as to what she observed on the video. I sustain the Commonwealth's objection. My next question.
Okay, so I'll continue to ask the questions, and then the Commonwealth can object it, and the court can rule.
Yes, sir. And again, to the attorneys, I know that there have been a lot of objections, and there were a lot of objections yesterday, and it swirls all over. And sometimes I might be grumpy, but I'm not grumpy at the attorneys, and they are doing their job, so don't hold that against them. That was a cautionary instruction in the beginning. It is their duty to object, to make sure the rules are followed, and we analyze the rules of evidence. Okay, you may proceed, Mr. Rogers.
Okay, other than Dr. Parker, were you able to determine the conduct of any other employees that were at Richneck Elementary
Objection.
on January 6th?
Okay, and don't answer. So, and your question was, she able to observe, determine?
Observe the conduct, behavior of other parties, other staff members at Richneck Elementary School.
Okay, in reference to this incident?
Yes, ma'am.
Okay, and your objection is what, Mr. Jenkins?
Authentication, that she's testifying to that, what she would have seen on a video. She wasn't there. She can't authenticate the video, and she can't describe a video that counsel's not producing. the same
Response.
objection.
Your Honor, if I don't have the videos to produce right now, so she conducted an independent investigation. Obviously, she observed a lot of things by video. The court believes that she should not be able to testify as to what she observed by video. Then I'm prohibited.
So I sustain the objection because it's the same thing we just discussed. And
Right.
again, if it can't come into the front door, it cannot come into the back door. Next question.
All right, I'll go to the, let me first talk about you being a custodian of records. Have you testified as a custodian of records for Newport News Public Schools previously?
Yes,
Okay. And so you're the custodian of this document, is that correct?
correct.
Okay. All right. If you'll turn to page 17 of this document.
Yes, sir.
Okay, it talks, I guess, about halfway down. It says teacher removal of a student from class.
Yes.
Actually, let me start at the very top. It says disruptive students in the classroom. Could you read that first paragraph, please?
Under the disruptive students,
Yes, ma'am.
the code 22.1-276.2 provides statutory guidance related to the initial authority of a teacher to remove a student from class for disruptive behavior. The code 22.1-276.01 defines disruptive behavior as a violation of school board regulations governing student conduct that interprets or obstructs the learning environment. The provisions set out below are supplementary to and are not intended to replace the authority of a teacher or administrator to discipline students according to rules described in this handbook. It is the school board's intent that the process of working with students and parents should be focused on seeking solutions to eliminate disruptive behavior in order to improve student achievement and student citizenship.
Okay. So would you agree that this paragraph, which cites Virginia Code 22.1-276.2, gives a teacher the authority to remove a disruptive student from her classroom?
Objection, that's improper opinion testimony. She's not been qualified as an expert to answer that.
Response?
Your Honor, she is here as an agent of the Newport News public school system. She can advise whether or not she believes that Virginia Code allows a student to be removed by the teacher. It spells it out pretty clearly there, but I just want her to verify.
Just rephrase it. I think you can rephrase it as to not to what her opinion is, but as to what's in the manual.
Does this manual, which cites Virginia Code, give a teacher the authority to remove a student from the classroom?
Yes,
Regarding your investigation, was JT ever removed from the classroom?
Objection, Judge, this is getting into the findings of her investigation now, which is the province of the jury to decide.
And your response?
Your Honor, I'll submit that to you. I'm not asking for a finding. I'm not asking for a conclusion. I'm asking for a fact. I asked her to determine if something actually occurred or did not occur. That's not a finding.
Okay. So again, legal conclusions are a problem for the jury, but how does the finding of this school investigation not come, well, how is that not relevant and admissible?
Judge, the investigation is findings of fact that lead to a legal conclusion. And we have a jury who are the fact finders for this trial. So any findings of fact that are based on her investigation are the province of the jury. And beyond that, Judge, this is beyond the scope of my direct. I did not ask Dr. Parrish opinions or ask her to give any conclusion about any aspect of her actual investigation, because that's the province of the jury.
I'm going to allow it, and over the Commonwealth's objection, the court's rationale is, the Commonwealth has introduced the school handbook, the policies and procedures, and the crisis management. And there's been a lot of evidence and questions towards, was that followed on that day? So that's a proper subject for cross-examination. And what the school found and all the school policies can come into evidence. We can have a curative instruction later, parties want, that the school findings are not legal findings and legal conclusions for this case. And that is for the fact finders. And that is to the criminal charge of child abuse and neglect and endangerment, not to whether or not the school procedures were followed. So that finding of that investigation is not a legal conclusion. So that's the court's basis. I'm going to allow it in. You may proceed, Mr. Rogers.
Thank you. So Ms. Kovac, if she was having some problems with JT, if he was being disruptive, there was nothing that prevented her from removing him from the classroom. Is that correct?
Correct.
Okay. Are you familiar with Ms. I think I mentioned the name Kovac. I meant Zwerner. So I meant Zwerner. Could you answer the question in regards to Mrs. Zwerner? She could have removed JT from the classroom. Is that correct?
Correct.
Okay. And if Ms. Kovac had contact with JT and thought that he was being disruptive, she could have removed him from the classroom. Is that correct?
Correct.
Okay. If Ms. West had some contact with JT on the playground as a teacher, she could have removed him from the playground. Is that correct?
Correct.
All right.
Relating to violent crime and alcohol usage.
Yes.
Okay. What do you do currently as a
This is a plan for each individual school. Is that correct?
Correct.
Okay. And are you, who's responsible for producing this document, if you know?
That would come under our safety security department.
Prior to this incident happening, were you familiar with this document?
I know that the schools have them, if you're asking if I'm familiar with this particular one prior to that incident. No.
Okay. And so you have become familiar with this document since this incident has occurred. Is that correct?
Correct. And when you say familiar, again, the custodian of records, it was presented to me. I was not the writer of the document.
Okay. So you said it was presented to you. Other than testifying here today in court, had you read through this document?
To the entire document, no.
Okay. So your familiarity with this document, was it in preparation for this trial?
For the previous one and this one.
Okay. And would you agree that the policies and procedures in this document apply to everyone that is a employee of a particular school?
Yes.
Okay, so this document would also apply to the teachers in the classroom, is that correct?
Correct.
It would have applied to Ms. Kovac as a reading specialist, is that correct?
Correct.
Mr. Rawls in his position, is that correct?
Yes.
All right. And so based on these two documents, was there anything in these two documents that prevented Ms. Ms. Zwerner, Ms. Kovac, Ms. West, or Mr. Rawls from removing JT from the classroom?
No.
Is there anything in these two documents that prevented any of those four individuals, Zwerner, Kovac, West, or Rawls, from removing his classmates, JT's classmates, from his presence?
No.
So I'm going to actually go to the page 60 in the multi-hazard crisis and emergency management plan, which the Commonwealth directed you to.
Speak up for me, Mr. Ross.
Okay. Did you hear what I said so far?
I heard you say you were gonna go to page 60.
That's correct. Okay, and even when he directed you specifically to a weapons threat. It says if a student or other person makes a threat with or about a weapon, it has bullet points. Are you testifying that each one of these things should occur?
Say that last part again, I'm sorry.
Are you testifying that each one of these things under this weapons threat should occur?
Objection, judge calls for an opinion.
Response?
Your Honor, this is the policies and procedures of the school. She's here as an agent of Newport News Public Schools. She can tell us whether or not it's the responsibility of Newport News Public Schools employees.
That wasn't your question. She can answer what does the manual say, but your question was whether or not it was applied or followed in the circumstance. So I'm going to sustain the objection.
Okay. So I'm going to ask it in a different way, if I may. Ms. Zwerner, Ms. Kovac, Ms. West, and Mr. Rawls, was it their responsibility to follow these procedures?
Objection, same objection. He's asking for an opinion of whether they should have followed certain procedures.
All right,
All
well,
of them or few of them.
Response?
I can rephrase it to make it more clear, I guess. Are they obligated to follow these procedures? And I let him say this objection.
Okay, do you object to that phrasing?
It's been asked and answered, but I don't object.
Oh, you may proceed. With that specific phrasing.
Okay, thank you. So you would agree that if they thought that there was a weapon, that each of those individuals should have evacuated the area. Is that correct?
Correct.
For each of those four individuals, if they believe that there was a weapon, they should have.
Objection, Judge. This isn't the question that the court. He proposed to ask her, are they required to follow these policies? That was the question he proposed. That's the non-objectionable question. But he's going down into each of these policies and asking her whether specific people should have followed them at a specific incident or time. And that is an opinion. She has not been qualified as an expert in school security or any such thing. And she should not be offering an opinion about it.
It's not an opinion. She's testifying as to their rights and their responsibilities, Your Honor. So I believe she can testify to that.
Restate your question.
Was it their responsibilities when presented
Was
with?
it whose responsibility?
Ms. Zwerner.
That's the same question, yes, that I sustain the objection to. Next question.
Okay. Can I have a moment, Your Honor?
Yes, sir.
Ms. Ferris, Dr. Ferris, are you familiar with the training that Dr. Parker or anyone else may have had regarding the rights and responsibilities that are contained in this handbook?
No, I am not.
Okay. And would your response be the same to this document? Are you aware of any training that Dr. Parker or any of the staff members may have received regarding?
No, I am not.
Ronna, I'm going to relinquish this witness to my colleague.
To your colleague, Mr. T?
Mr. T.
Okay, Mr. T.
Thank you.
Your Honor, for the record, I'm going to object to bouncing back and forth between attorneys for a single witness and
It's not ideal, but I don't have any authority that says they cannot. Understood. And I think you dropped something, Mr. T.
Oh, thank you. Good morning again, Ms. Ferris. Are you Dr. or Ms. Ferris?
Doctor.
Dr. Ferris. You were shown a video of about 16 minutes earlier during your testimony, correct?
Yes.
Okay. At certain points of the video skips forward, correct?
The entire video, I didn't see a skip, but I saw a muting at certain sections.
Okay. So are you aware that the entire video was 28 minutes or 28 or 29 minutes?
Based upon the timeline I saw,
Okay. And you were shown about 16 or 17 minutes, correct?
yes, as I recall.
And is it your understanding that the video clip that you were shown contains 3 different clips joined together?
The video that we saw here
Yes.
was the whole video except the end. It stopped before the very end. So I'm not aware that it's in snippets, it's the whole video.
Okay. So I'm gonna pull up the video, the actual video, the whole video.
Judge, I'm going to object to this. I don't know what the relevance of this is.
Okay. And I'll give him a moment to respond to relevance.
I'm going to ask the council not put that up on the screen until we've addressed.
That's fine.
Okay, he's objected to relevance. What is the defense response?
It's relevant. The witness has testified that she does not believe that the video has been cut up and, certain parts edited out.
Did she say that, or did she say she wasn't able to see that?
She says that she believes that the entire video was shown except the end. That's what she just testified to.
Okay. And what are you purporting to introduce and under what legal admissibility rule?
So best evidence rule, the Commonwealth has spliced the video, and he's cut out and skipped ahead in the video.
Which we acknowledge.
We acknowledge. So I would like to play more of the video that gives fuller context to the testimony that Dr. Parker was giving in the video.
Okay. And again, we agreed that the jury would get the whole video for deliberations. So your objection and what you're going to play is a part of this whole video.
Yes.
Okay. And so what's the objection?
Well, Judge, it is going to be in evidence. I've already fully stipulated that the version we showed is an edited version and the full video goes into evidence. Now he's wishing to introduce evidence. We don't have that video, the full video in. So the defense is about to introduce evidence that he has. which they can certainly introduce evidence in their case, but this is still the Commonwealth's case.
So the legal principle here, when we start with my ruling, I'm going to allow it in over the Commonwealth's objection. The basic thing is the whole video is going back there to the jury room for deliberation, and it's offered by the Commonwealth. The opposing side gets the right to cross-examine that, and to have it go back there with the ability to cross-examine is not a legally sustainable principle, does not comply with case law. So he gets the opportunity to cross-examine on anything that's going back there in the jury room. So that's his court's basis. You may proceed, Mr. G.
Thank you, Your Honor. And Dr.
Judge, I'm sorry, I just want to advise that the full video many times contains the name of JT.
Okay, the whole name, not initials.
Correct. the
Okay,
whole
but
name.
how are we dealing with that, Mr. G?
Your Honor, I don't intend to play any portion that gives the name. I can ask some additional questions if we can. I can try to avoid
We're
it.
talking about, again, audio and press coverage to the world.
I understand.
So
Yeah.
you're able to not to play portions that do not state and the names of any minors.
Yes.
Okay, you may.
But just to be safe, I'll just try to listen to testimony from her directly, and then if I need to, I'll play the portions that I
Are you
need to.
playing video or not?
It would just depend on her answers.
Okay, you might,
Okay.
okay, but understand, we have that
I
cautionary
understand.
instruction, we are not releasing the names of any minors. Okay, you may proceed.
Thank you, Your Honor. Dr. Ferris, during the narrative that Dr. Parker was giving you in the video of what occurred that day, her actions, did she also mention that in the midst of all of this, she was also attending to two other students that were acting out?
Yes.
Okay. And that was not played in that video that you heard earlier, was it?
I'll just refer back to my notes.
Not just in her office, ignoring the rest of the school during the testing, correct?
Objection, it's an opinion about something that she did not observe.
I'll rephrase the question, Your Honor.
Please do.
From Dr. Parker's testimony to you regarding the events of the day, she mentioned that there were two other student issues that she dealt with in the school, correct?
Objection, that was the most recent question that's been asked and answered.
I want to narrow down and go down the path of asking about these two other.
Okay, repeat your question again.
During the day, during the narrative that Dr. Parker gave you, Dr. Ferris, of what was going on regarding her conversations with Mr. Kovac and Ms. Zwerner, she also mentioned that there were two other student issues that she dealt with regarding misbehavior, correct?
Okay, hold on, that's the question, what's the objection, Mr. Jenkins?
This is the second time he's asked that question. Her answer is yes.
Also, just ask and answer.
Yes.
Okay, you can ask it one more time. You can ask it, just go ahead, so overrule.
Okay. Do you need me to repeat the question, Dr. Ferris?
Yes, she responded to other issues, to
Okay.
other students' issues.
Okay. And one of them being a student was trying to elope from the school, correct?
Correct.
Okay,
Or a student who was an eloper, and there
An
was
eloper.
something that happened.
right. And that was prior to the shooting, according to your interview of Dr. Parker, correct?
Correct.
Okay. Dr. Ferris, you are an agent of the Newport News Public Schools, correct?
Yes.
All right. And you are aware that the Newport News Public School System is named in civil lawsuits stemming from this event, correct?
Correct.
Okay. And so your employer has a direct financial interest in these proceedings, correct?
Explain that a little more to me.
Would you, it's from, as far as you understand, would your employer benefit financially from having Dr. Parker be the one to blame for the shooting?
Objection,
I don't know
Judge,
how to
I
answer that.
hold on, objection. That calls for a legal conclusion. She's not an expert in litigation or how that works. And the question assumes facts that are not in evidence regarding another matter of time.
And her foundation for having that knowledge or information, so sustained.
Okay. You interviewed Dr. Parker within 2 or 3 days of the shooting, correct?
Correct.
And she gave you permission to interview her and be recorded, correct?
Correct.
Okay. And she cooperated fully with you, correct?
Yes.
You also told her to keep the conversation confidential, correct?
Correct.
Did you ever tell her that she had the right to have an attorney present before speaking to you?
No.
Okay. Did you ever tell her that anything she said could be used against her in a criminal proceeding?
Objection, Your Honor.
Her basis for your objection?
Judge, we're gonna need to address this inside.
I'm asking her what she advised Dr. Parker during this interview.
I'm going to sustain the objection. Next question.
Okay. According to your interview with Dr. Parker directed Ms. Kovac to search JT's backpack, correct?
Correct.
Okay. And as far as what Dr. Parker told you, Ms. Kovac did check the backpack and found nothing, correct?
Correct.
Okay. Ms. Kovac also told Dr. Parker that they watched him closely, correct?
If I remember, the phrasing is that they were watching him.
Watching him closely.
Correct.
Okay. So is it your understanding that Dr. Parker had been told that there was no gun in the backpack and also that he had been closely watched during recess?
Objection, can we clarify that what we're asking her is about the statement, not about the facts of what happened, but about the statement of Dr. Parker?
Sustained, can you rephrase to clarify what you're referring to?
Okay. Well, I've already asked the questions. Dr. Parker also stated that JT's mother would be coming to the school to get him shortly, correct?
Correct.
Okay.
There is something in background noise. I'm not sure where it's coming from. I don't know if it's somebody's cell phone or, but we could try to take care of it.
Yes, I keep hearing it and it's distracting.
Okay, well, the sheriff will be on top of that. And I'm hearing it to be, we'll work on it. All right, thank you. And again, 12:23, we'll keep going. Again, we'll try to go to 1 for lunch, but do any of the jurors need a break? Okay, they indicated good. Okay, proceed with your cross.
Thank you. Dr. Parker also testified or said to you during the investigation that Ms. Zwerner never stated that the student had a weapon, right? May I ask what you're reading?
It's a transcript of the video.
Okay. Do you have any independent recollection of?
I don't remember her saying Zwerner said the student didn't have a weapon. I asked her, did Ms. Zwerner ever say she had concerns about the student and the student being a threat to her or her feeling unsafe?
Okay. Do you recall when the video was played here in the courtroom?
That's what I was trying to remember if Ms. Zwerner said that. I remember Ms. Kovac saying she did not see anything in the backpack.
Do you recall the video today where Dr. Parker was speaking to you in an interview and she stated that Ms. Zwerner never came to her and said that the student had a weapon?
That, yes.
Okay. And everything that Ms. Zwerner related to Dr. Parker was about behavior of the student, correct?
Correct.
She also mentioned that they had, prior to this incident, that they had two incidents at the school where there was a potential weapon possessed by a student, correct?
You're referring to two other times?
Prior to January 6, 2023.
Correct.
Okay. And she also mentioned to you that they've never searched the student without the parents' consent, right?
That they've never searched students.
Okay. And she was also managing state testing that day.
Correct.
Based on your investigation, did you conclude that this was foreseeable? The shooting specifically was foreseeable?
No.
Right. In fact, you came to the opposite conclusion, correct?
That is true.
In fact, you said that this is something that none of you could have ever imagined, correct?
I'm going to refer to my summary.
At any point, did you say something to go to?
Okay. I just asked for a moment to refer to her notes.
Okay.
I do not recall making that specific statement.
Mhm. Okay, but you do agree that this, based on your investigation, that this is not something that was foreseeable?
Correct.
Okay. Did you ever make the comment in the civil trial of this matter that this was something that you could never have imagined?
Objection, hearsay.
It's her own statement.
Correct. It's her own out-of-court statement being offered here for the truth of the matter. You can ask her what she believes today, now, but not what she said out of court.
I thought he said during the civil trial. Does that make it in court, or am I missing something here?
It's out of court because it's not within this proceeding. Yeah.
She says that she cannot recall, she could not at that time recall making a statement, and I believe she believed I was asking her about the actual report itself that she created.
Okay, well then rephrase, because that's not the question that I understood.
Okay. Did you ever make a statement during the civil trial that this was not a foreseeable incident?
Okay, and hold on before you answer. So assuming she says yes, which I don't know what her answer is going to be, are you going to ask her to then give that statement?
I'm just want to know whether she made the statement.
So you just want an affirmative or a negative response?
Yes.
And your position is changed?
He's feeding her the statement and just asking her, say, didn't you say at the civil trial? He's going to give her the statement and he expects her to say, yes, I did say that at the civil trial.
I just asked another question. I said, did you ever make a statement to the effect that it was not foreseeable? That was my last question.
Exactly, to the effect that it was not foreseeable. At the civil trial, that is hearsay.
Okay, yeah, understood. your response to that, Mr. Chief?
Your Honor.
It's admissible. What exception applies?
I can ask her about her statement. This goes to the foreseeable. You know what? I will try to question Your Honor. She's already answered that she has determined that it was not foreseeable. So I'll try to question. Okay. No further questions.
All right. Any redirect?
Yes, sir.
Dr. Farish, much has been made about your investigation. Do you have, as part of your investigation, did you complete a Richneck investigation report?
Yes,
And do you have that report with you right now?
yes.
May I approach, Your Honor?
You may.
Sure. Will you have a copy? Judge, I've provided to the defense counsel a copy of the plan. Do I need to wait?
To review what you're presenting to the witness.
Of course.
To make sure that it is the same. Okay. Okay, you may approach.
Thank you. Could you just take a moment to just look at each page of that, compare it with the one you brought with you, and let us know if it's an identical copy?
Yes,
All right, so is that a fair and accurate copy of your complete, full report of your investigation?
yes.
All right, Judge, I move to admit that as Commonwealth's 3.
I'm going to object to the investigation, confidential information, that investigation report that contains hearsay from other parties. It is not admissible.
Response.
The court's ruled otherwise already. Counsel has been allowed to elicit her opinion, the results of her investigation. Counsel has cross-examined her about the conclusions that are in that document. We have had a full interrogation about the facts found by her investigation and her conclusions. To not give the jury that document now is misleading. And so for the rule of completeness, the defense has been allowed to go in and talk about cherry pick little pieces that they want to talk about. And I'm seeking to admit the whole document so the jury can see it for themselves.
Mr. T.
Your Honor, we are on cross-examination allowed to ask about anything we want to ask about. It's smallest in the scope of the direct examination. This is a report that contains hearsay statements from other parties. Just as the court has ruled that the jury cannot consider the statements of other people that were mentioned in the video, giving them a full report complete with hearsay is beyond the veil. It's not admissible.
Okay. Let me see the document. to make a
Of course, may I approach the, oh,
You may.
the deputy has it.
Yes,
Yes,
please.
of course.
Thank you. Appreciate your long work.
You are aware that, Dr. Parrish has not been qualified as an expert.
The court will allow a redacted version in, so I will sustain the defense objections as to some of this are not admissible based on the rules of evidence. The court's position is that page 1 and page 8 come in. So the cover sheet and the last page come in, the middle does not. I will remove this tape from myself. And does the Commonwealth want the portion removed to be marked Commonwealth rejected?
Yes, please, Judge. Thank you.
Okay. Thank you. Where Madam Clerk is amazing. Commonwealth, this where 3, Commonwealth 3. Rejected 1, rejected Commonwealth 1. Okay, you may proceed with your redirect.
Judge, may I retrieve Commonwealth's 3 from the court to bring to the witness?
Yes, and I'm gonna ask. Your state course work just as good as my state course. Okay. Yes, sir.
Dr. Parrish, for the purposes of these questions, I'll just ask you to refer to Commonwealth's 3, which I have just handed you after it's been marked and entered by the court. There is a section on the second page of the 2 that were marked called Summary and Conclusion. Do you see that section?
Yes.
Could you please read it?
Yes. An investigation was conducted to review internal processes and establish if there were any deficiencies. From interviews, several employees were told that the student had a weapon. All instances were reported to Dr. Parker, assistant principal. An inquiry was made to Dr. Parker if the student could be searched.
Again, I'm going to object to hearsay. Those are statements coming from other people.
You asked for the finding to be in evidence, the findings in evidence. So noted your objection, overruled.
Please continue.
The book bag was searched independently by Ms. Kovac. Permission was never given to search the student. At no time was the principal, Ms. Foster, notified of any communications about the student and the alleged weapon. Dr. Parker never left her office to investigate the situation with the student. Dr. Parker never spoke to Mrs. Foster, although they communicated about other school business prior to the incident. Dr. Parker admitted to handling a prior search situation with another student earlier in the school year, where she brought the student into her office to conduct a search. Although she says previous students' persons was not searched, she admitted that these students were pulled into her office to search their belongings at a minimum. This process was completed with the police or another adult present. Dr. Parker never left her office on the 6th to pull JT into her office. Dr. Parker responded that she could not leave her office due to testing as the reason for responding personally to the report of the student possibly having a weapon. Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and Dr. Parker all had knowledge that the student was in possession of a possible weapon before 2 p.m. Root cause: failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Lack of urgency and attention to multiple notifications. Lack of training and knowledge of the staff on how to handle this type of threat.
Thank you. May I approach the witness, Judge?
You may.
I'll retrieve Commonwealth 3 back from you and return it to the court clerk.
Thank you.
Now, Dr. Farish, previously when I was questioning you and then again with defense counsel, you were asked to read various sections of the Rights and Responsibilities Handbook, including that section on page 28 about principals and security officers under the direction of a school administrator may search students. Do you recall that document?
Yes,
All right, and that document is an authentic manual that provides all the policies that were in place at Richneck in the 2022-2023 school year?
the Rights and Responsibilities Handbook for the district for 22-23.
Yes, that's an official document of the district.
Yes.
Judge, I move to admit that document in whole into evidence as Commonwealth Court. I'll have to retrieve it from the witness.
Okay, you may approach.
Before that's,
Yes, sir. And you can still retrieve it, Mr. Jensen, and you can pass it to Madam Clerk. I won't receive it until I get you the defense counsel.
the court's already ruled that it comes in, so.
All right, so this will be marked Commonwealth 4.
May I approach the witness, Judge?
You may.
Dr. Farish, could you take a look at what I just handed you and identify it?
Yes, this is the Newport News Public Schools, Richneck Elementary 2022-2023 Multi-Hazard Crisis and Emergency Management Plan.
And is that a copy of the same document that you have that is the emergency management plan that I have asked you about and defense counsel has asked you about?
Yes.
Judge, I move to admit this in whole, unredacted as Commonwealth's 5. May I approach the witness?
You may. Yes, yes, continuing objection, which was previously ruled on and for the record was made contemporaneously.
And I have no further questions for the witness, Your Honor.
Thank you. Any recross?
Yes, sir.
Okay, briefly.
Briefly, Dr. Farish. Again, the portion of the report that was just entered into evidence, your investigative finding, you were conducting that investigation on behalf of Newport News Public Schools, correct?
Correct.
Okay. As far as your findings, you were not assessing or giving up any opinion on whether Dr. Parker's or anybody or any other employee's conduct was criminal in nature, correct?
Correct.
You also mentioned in your root cause section of your report, a lack of training and knowledge of the staff on how to handle this type of threat, correct?
Correct.
And you're referring to the staff as a whole, correct? And according to your report, all of the, I'll just name them specifically, Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, Mr. Sims, and you say Dr. Parker. Your finding is that none of them responded adequately, correct?
Objection, Judge, I think that misstates the evidence.
It responded adequately. I do think it's a misstatement. Can you rephrase?
Okay, all right. In your root cause section, you write, failure to follow a process and to appropriately detain a student and conduct a proper search once first notified that a student has a possible weapon. Does that apply to all of the people I just named, Ms. Zwerner, Ms. Kovac, Mr. Rawls, Ms. West, and Mr. Sims, and Dr. Parker?
Yes.
Okay. No further questions, ma'am?
I have a follow-up, Judge.
Yes, sir.
In the root cause analysis section, is there a phrase that cites the failure to search?
Yes.
And according to the Rights and Responsibilities Handbook, what does it say about who may conduct a search specifically?
That was the one.
We took
I
it away
had
from you.
taken.
Can
That's
I,
okay.
can I please retrieve Commonwealth's?
You may.
5, the Rights and Responsibilities Handbook. And I can give you a page site. I'll direct your attention in Commonwealth's 5 to page 28, the paragraph that begins principals and school security officers.
Mhm. Principals and school security officers, under the direction of a school administrator, may search students and student property.
All right, so given the root cause analysis that involves the failure to search, who was authorized by the district's rights and responsibilities to search?
The school, under the direction of the school administrator.
Okay, and are teachers that work in a school considered school administrators?
No.
Are reading specialists that work at a school considered school administrators?
No.
All right, thank you. I don't have any further questions for you.
Okay, so this, so that paragraph, it starts out principals and school officers. And then it, comma, under the direction of a school administrator.
Objection, I object to counsel reading whatever he's reading from. The witness should be the one reading from the exhibit that the witness has.
Are you reading the same thing the witness has?
Yes, ma'am.
Okay, then go ahead. You may proceed overruled.
All right, so I'll read it again. Principals and school security officers, comma, under the direction of a school administrator. So would you agree that when it says under the direction of a school administrator, it's referring to somebody other than a principal or security officer?
The verbiage we use at the school district for administrator includes a principal and assistant principals. They are administrators.
Okay, but as this is read, it seems to indicate that they need to have the direction of somebody above them. Do you not see that?
Under the direction of a school administrator.
Principals? Okay, so if I take out, it says principals, I can take out and school officers. So principals, comma, under the direction of a school administrator. So that seems to indicate there needs to be some authority above the principal. Do you disagree with that?
Same, Mr. Jenkins, same. Next question, Dr. Rogers.
Yeah, that's all I have.
Okay, the status for this witness, may she be excused or does she need to remain sequestered?
I ask that she remain constructively sequestered, but of course able to.
Mr. Rogers?
Yes, Your Honor, we
We
agree.
concur, okay, all right, so Dr. Parrish, that means you are still a witness for purposes of this trial. You cannot discuss the case or discuss your testimony until you receive information that the trial is over. But you do not have to remain in the building or the witness room. You can go about your day, be available by phone if we need to call you back for your testimony. Okay, and you'll be informed, when your sequestration ends and when you're released from the witness obligation. Okay, thank you, ma'am, and why I accept that you stepped in.
Thank you.
All right, can we do another witness in about 10, or start with another witness about for the 10 minutes or so? I want to use up our time.
Before we call another witness, I would step out, so.
Okay, yes, Mr. Jenkins.
If we're going to need to take a break here, it doesn't make sense to call another. The break will take 5 minutes, and then we'll only have 5 minutes of a witness.
Okay, so it is 12:51. We will start our recess for lunch. For the attorneys, are there any motions, objections that we need to take up before we resume evidence? Meaning, I'll tell the jury to report back at the jurors at one time, and I'll tell you all a different time if we need to work out issues.
There's nothing from the council.
I think we're good.
Okay, so I'm gonna keep a tight schedule. Jurors report back at 2, attorneys report back at 2, and we'll get going. And there should be lunch back there. Again, jurors, your recess instructions. Do not discuss the case, do not research the case, do not allow anybody to discuss it with you. I will check in when we return. You are welcome to leave the building, or I think we have Subway for you today, if you wish to partake, or of your own lunch. All right, Sheriff McGill, escort them to the jury room, and we are in recess. Thank you.
Please rise for the jury.
And the media can come and
Leave your
turn on
notebooks,
their,
please.
audio. take up before we bring the jurors out?
Nothing from the Commonwealth? We're good.
Okay, Chair, please bring out the jurors.
Please rise for the jury. Jurors in the box.
All right, thank you so much. You all may have to take your seats. We have jurors in the box. And to the jurors, are there any issues to report to the court? Okay, nothing has been said. All right, next witness, Mr. Jenkins.
Commonwealth calls Mark Garcia.
Good afternoon. Come stand in front of Madam Clerk, please.
Raise your hand. Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Okay, sir, take the witness stand, please. Watch your step. Okay, you can adjust the microphone. Please answer questions the attorneys may have.
Good afternoon, sir.
Afternoon.
Would you please tell us your name?
Mark Lincoln Garcia Senior.
All right, sir. And I know that I mentioned this to you earlier, but just as a reminder, we're not saying the names of any children at all today. You're welcome to use initials or refer to them, my son, for example, but no names. I want to, do you have a son?
Yes.
And what is his initials?
MJ.
Did MJ attend Richneck Elementary School?
Yes.
Was MJ in attendance at Richneck on January 6, 2023?
Yes.
How old was he then?
7.
On January 6 of 2023, did you go to Richneck Elementary School? Well, first of all, let me ask you this question. Did you take MJ to school?
Yes.
So was that in your car? Did you personally drop him off?
Yes, I drop him off every day.
Okay. And on that day, did you go back to Richneck Elementary School sooner than you normally would?
Yes.
When you arrived there, I want you to describe what you saw occurring without telling me what anyone was saying.
Okay. Well, getting there was a task because once you get to Jefferson, going down Richneck, it was kind of like caught on off by the cops and a lot of people trying to go there. So we had to go to the adjacent road, which is Monroe, and we had to come down Monroe. And we got to Monroe, we had to stop because there's a lot of cars. So I parked my car in somebody's house and he said we could park there. And I got out my car and I parked my car and I went down the road and there's a church that's on the right-hand side. And that's where everything was caught on by the cops. And that's where all of the confusion was going on because nobody knew what was going on.
So did you go to that church area where people were gathering?
We were in the middle of the street.
Okay. And did you immediately see MJ there?
No.
Okay. From the time you arrive, and I know I'm asking you to estimate, but can you give us an estimate? Are you able to give us an estimate of how long it was from the time you arrived at Richneck to the time you saw your son?
Response.
This is the connection, Judge, that we have been talking about in this case between the shooting and the ensuing trauma to the children. And that came from a delayed reunification. And that came from, as we will hear in a moment, that came from the continued chaos leading to these children in a panic and a state of trauma.
Your Honor, I'm going to continue to object. Even his response to this is a narrative testimony in front of the jury.
What's the nexus to why we're here? And I guess I'm missing that. If you can expand on that, if not, it's sustained.
The nexus for why we're here. Let me look at the statute and read from the statute. 18.2, 371.1. Any person responsible for the care of a child under 18 whose willful act or omission in that care was so gross, wanton, and culpable to show a reckless disregard for human life is guilty of a Class 6 felony. As to how
A delayed reunification.
the shooting, Judge, the shooting occurred, and everything that has happened to these children is a follow-on from the shooting that establishes it is gross, wanton, and culpable behavior of Dr. Parker. It was the willful omission that caused these children to be separated from their parents in a state of chaos.
I sustain the objection. Next question, please.
Mr. Garcia, after you were reunited with your son, describe his demeanor, how he looked to you.
Objection again to relevance, Your Honor.
You can describe that out loud. Overruled. You may answer the question, sir. You need him to repeat it?
Okay. My son looked confused. He was very scared and very shocked that all of this took place in his school, which he loved.
All right. And are there any ways that you've noticed as a parent that your son is different was different after the shooting versus before the shooting?
Yes.
Describe what you noticed.
Objection to and objection to relevance.
Okay, and I didn't hear, okay, leading and relevance. He can describe what he observed when he sees his son. Go ahead, overruled.
So my son, he's in therapy. He has to go to therapy now. He's still scared of the dark areas in which they have to be pushed into a safe room. He's not comfortable in certain situations like he used to be, like being talkative and things of that nature.
Objection, Your Honor. If I can just have questions.
Yes, sir.
Even regarding the statute, things the county has approved, this is, the things that he's testifying to is not a material fact that has to be proven or established to prove that Dr. Parker is guilty of this crime. He's testifying as to things that occurred afterwards, but nothing regarding Dr. Parker's conduct or lack of conduct. So it's not relevant.
Response?
Child abuse and neglect requires a showing that the abuse is so gross, wanton, and culpable that it showed a disregard for human life. The effects of the abuse are what he is testifying to. That is what is gross, wanton, and culpable. And we're there. This is as far as I'm going with this. But the fact that the child is different after than before is relevant to whether the choices Dr. Parker made were gross, or the omissions were gross, wanton, and culpable, because this is the after effect to the children.
It can end here, but again, I'll let you finish, Mr. Rogers. But as to where we are now, I'm going to overrule defense objection. You can ask that one question. The gentleman may answer that question, but then we're going to stop. Yes, Mr. Rogers.
Your Honor, I might agree with Mr. Jenkins that the Commonwealth had to prove some type of serious injury, but that's not what's charged. It's felony abuse of neglect, but it's not based on any injury. It's based on conduct and not any impact on these children.
Anything additional?
Not from me, Judge.
Okay. Do you need the attorney to repeat his question?
Yes, please.
How was your child different after the shooting versus before?
Yes.
Describe how he was different after.
Would you like me to describe before?
If
You
you,
have to answer the question that he asked.
Okay. So after, again, my son, he doesn't like sleeping in the dark because of being in that safe room for however long they were in that safe room, being confined to an area, having, I don't know how much light it was, but he's scared of the dark, having added more light and going to therapy.
and were any of those things present prior to the shooting?
No.
All right, thank you. I don't have any further questions.
Good afternoon, Mr. Garcia.
Good afternoon.
I just have a few questions. Are you familiar with any relationship that your son had with Dr. Parker?
No.
Okay. Your son was a second grade student at Richneck, correct?
Correct.
So he was not in Ms. Zwerner's classroom, correct?
No.
Okay. You mentioned something about a safe room. Isn't it true that your son was in the gym?
No.
Your son was not in the gym when you
No.
picked him up?
No.
Okay. Where was he?
I don't know.
Oh, you don't know?
No, we were told by the
Oh,
police.
I'm not asking you to tell me what somebody told you.
Okay.
So you don't know?
No.
Okay. You filed a civil lawsuit arising from the events on January 6, 2023, correct?
Correct.
Okay. And it's filed here in this courthouse, correct?
Not sure.
You're not sure?
No. You have to talk to my attorney on that.
I'm sorry?
You have to talk to my attorney on that.
Okay. You have named Dr. Parker as a defendant in your case, your civil case, correct?
Correct.
And you're seeking money damages from Dr. Parker, correct?
I'm not gonna talk about that on camera because it's streaming.
Judge, I am going to make a limited objection here in that any civil suits relate to the children. And I think what he's requesting is that we not be on the air for this discussion and the cameras not continue recording while he discusses his child. And I support that request and ask the court to do that.
Response.
Well, Your Honor, he just asked a series of questions about the child on camera. I'm asking about a civil case, asking him whether he filed a civil case. It has nothing to do with the child himself.
So the objection is overruled. Cross-examination, the questioner is allowed to examine the witness's interest in a case. And for the witness, we are not using names, we are using initials as we previously did. So that is the protection to minors in this case. All right, you may proceed, Mr. T.
Mr. Garcia, you are seeking money damages from Dr. Ebony Parker in that civil case, correct?
Yes,
And a criminal conviction of Dr. Parker would assist in your civil case against her, wouldn't it?
I believe so.
So you have a financial interest in the outcome of this criminal trial?
Financial, what do you mean?
Well, you just stated that you believe that a criminal conviction of Dr. Parker would assist you in your civil case where you're suing for money, correct?
Yes,
Okay. So you would agree you have a financial interest in the outcome of the criminal trial, correct?
possibly, yes.
When did the school first contact you about the shooting?
January 16th.
16th?
Yes.
Okay, so 10 days after the shooting occurred. Okay. And how did you get that notification?
I was called by the city, the Newport News Public Schools, I forgot the name of the downtown director of people, but I know her name is, I know her name, but she called me at 6 o'clock on the 16th.
Okay. And do you consider that failure to notify you for 10 days a failure?
Absolutely.
And do you believe that failure is on the part of Newport News Public Schools?
I believe it's on the part of the school system as well as Newport News Public Schools.
Thank you. No further questions.
Any redirect?
Yes, Your Honor.
You've indicated on cross-examination that your son, NJ, was not in Ms. Zwerner's classroom. What was his homeroom?
His homeroom was Mrs. MacArthur's class.
And did he have occasion to interact with other students from other classes?
They're in the same hallway.
Now, in the immediate aftermath of this, when you picked him up, did he tell you anything about contact he had had with another student?
Objection, relevance, and hearsay.
Okay, and I was gonna ask you, are you asking me to give a statement or just to?
I am going to attempt to establish possibly an excited utterance.
Okay, all right, so there's an objection.
Yes.
What's your response?
What is the legal basis for the objection? I missed it.
If you can repeat, Mr. T.
Relevance and hearsay.
Okay, so it would be hearsay unless the court finds that the excited utterance exception applies. I'll need to lay a foundation for that.
Okay. So if you can lay a foundation, and to the witness, sir, when we ask you to pause, and we can make sure that the evidence is appropriate under the rules of evidence. You may proceed.
In the immediate aftermath of the event, right when you see your son, does your son speak to you about the event?
Yes.
Does your son tell you about a child he interacted with that day?
Yes.
Okay. And do you know who, just a yes or no question, do you know who that child is?
No.
Okay. When your son is telling you this, can you describe for us, without saying what he said, can you describe his demeanor, how he appeared and how he was acting and how he sounded?
He was scared, shaky, and nervous.
Okay. Did he relate to you something that had just happened earlier that day?
Correct.
Judge, I think that is sufficient foundation as to hearsay under the excited utterance.
Yes, sir. Anything from the defense?
Yes, Your Honor. Yes, Mr. Commonwealth has not established any foundation regarding excited utterances. We don't know how long before, and if we're talking about the shooting that had occurred at 2 p.m. and the father didn't pick up his child until sometime later in the afternoon. presumably hours later, then I don't see how it can qualify as an excited utterance.
May I respond to that, Judge?
Yes, sir.
The excited utterance exception is extended when the declarant is a child, because courts have recognized in Virginia the nature of being a child, and brain development means that the heightened experience of an emergency extends quite some time. There are cases that I will have to look up if the court would like that involve many hours long when the child is young. The younger the child and the more traumatized they are acting, the longer the extension of the excited utterance is.
I am going to sustain the objection. The legal basis would be as such. Reading Rule 2:803, excited utterance. So an excited utterance is defined as a spontaneous or impulsive statement prompted by a startling event or condition and made by a declarant with firsthand knowledge at the time under circumstances negating deliberation. Again, my pauses are to show the pauses and breakups and how to decipher that. It has not been established that the declarant, which would be the witness's son, had firsthand knowledge at a time, as he was not in the affected classrooms, and there's been no evidence other than being a student at school and since it happened, as to how he would have gained firsthand knowledge through an appropriate way. So I'm going to sustain the objection.
I'm going to request to voir dire the witness so that I can establish exactly that.
Okay, you're asking to do so out of the presence of the jury.
Yes, Your Honor.
All right. Ladies and gentlemen, if you kindly retire to the jury room, and we'll bring you out as soon as we can. Thank you.
Please rise for the jury.
Okay, parties may have a seat. And to the witness, you're still under oath. We're going to have some additional questions for you. But one moment, we'll wait for the door to close. You may proceed.
In that moment where you were just describing his demeanor, tell us what MJ told you.
That my son sits on the last seat because they don't have any doors in their classroom. So his seat, he could hear the pop. When he heard the pop, the teacher, they heard over the walkie-talkie that someone got shot. And they got everybody scrambled into the outside of the classroom, which was in the direct line of supposedly their safe zone, which is outside of their classrooms.
Okay, let me ask you this question. Did MJ say all of that to you in that moment?
Yes.
Okay. And so if I understand your testimony correctly, is it that he heard the gunshot and he was in a classroom that had no door?
Yes.
Okay.
He heard a pop, I believe.
A pop.
Yes.
And then he had to evacuate with the school, basically.
He had to evacuate his classroom in the danger zone.
Say that you're saying in or and?
In the danger zone, because his class has no door, so the zone of where they have to go out is outside of their classroom in that same hallway.
Okay, and he used the word danger zone.
My son?
Yes.
No.
Okay, I think he's asking you, what did the child say? I mean, the verbatim statement.
He was in his the safe room. He went to the safe room.
Okay.
Okay, and Mr. Rogers, you were standing up, did you want to say something?
I was going to address his characterization of dangerous.
Continue with the Rogers.
Judge, I'm not going to seek to admit the statement. We need to bring the jury back in. Thank you.
Bring the jurors back in.
Mr. Garcia.
And I know you all just stood, you can keep your seats this time, and I'll explain to them, I gave you a break, it was just a few minutes ago. You can bring them out, but everybody doesn't have to stand. And you all are welcome to have a seat once, everyone comes in.
14 jurors in the box.
Thank you very much. Jurors have a seat, and normally they stand, I told them they just stood, they didn't have to, so no disrespect to you all, it was just my command. You may finish with your questions if you have any more.
Yes, Your Honor. Mr. Garcia, had you personally ever been inside Richneck Elementary School?
Yes.
Had you personally ever gone to your son's classroom?
Yes.
And did your son's classroom have a door?
No.
All right, thank you. I don't have anything further.
Cross-examination?
I think we're fine.
Defense has no questions. Okay, all right. And the status for this witness?
I would ask that he be released unless there's an objection.
He can be released.
Okay, so what that means is you're released from your obligation as a witness. You may stay in the courtroom, you may leave and go about your business, and thank you, sir.
Thank you so much.
And next witness,
I'm going to call Susan White.
Susan White.
Susan White.
Thank you.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? You just have to see it.
Your Honor, if I may,
Yes, sir.
I know the court is already ruled on, Mrs. White's,
And come on, and hold on one second. Come on in the witness stand and watch your step, and yes, you can move the chair and microphone. Yes?
the court's already ruled on Mrs. White's ability to be able to testify. We're doing my objection, to the testimony she will give regarding how it's not relevant to what happened on January 6th regarding my client's, conduct, the act of omission that occurred on it today. She can't testify to that because she didn't prove it. So, I don't believe that she has anything of relevance to offer the fact finding to be able to decide, if my client's conduct is appropriate.
So noted, thank you. You may proceed, Mr. Shingle.
Good afternoon. Tell us your name.
Susan White.
Ms. White, how are you employed?
Right now I'm retired.
And on January 6th of 2023, how are you employed?
I was retired by then too.
Okay. And were you at Richneck Elementary School?
Yes, I was.
Why?
I was there for 34 years.
Okay.
And my last year was the year before
Right.
that happened.
And so I want to take you back to the year before that, which was that your final year before retirement?
It was.
Okay.
I'm sorry, I don't believe her answer was responsive to the question. There may have been a misunderstanding as to what was asked, so definitely wasn't.
Okay, you can clear that up on cross-examination. You may proceed, Mr. Jenkins.
So during the course of your last year of teaching at Richneck, did you know a student who we're referring to as JT?
Yes, I did.
Okay, and as a reminder, we're not speaking the names of any students at all, only using initials. Whose class was JT in?
My class.
And what grade was that?
Kindergarten.
During the course of your time with JT, was there ever a discipline incident that you did report directly to Dr. Parker?
Yes.
I want you to start at the beginning of that incident that you eventually reported. So what was going on that day that began that?
He had gone up, this was during post-COVID, so we had to be careful with distances and with masks. And he'd gone up to the front of another child's desk with his chair and put his face over about 3 inches from the other child's face. And so I had to think, what am I going to do about this? Because just telling him no, or you need to get back to your seat or whatever, those weren't working with him. So I slid the chair slowly so that if he wanted to get up, he could get up. And if he didn't want to, he could stay seated. I was going to bring it to his desk. But then he pulled the legs away and dropped them. And so I brought it up a little bit further just so I could be right in front of the class. And I sat there and I kept on teaching because I was still talking with the students.
Let me pause you for a moment so we can kind of visualize this scene. So when he is in the face of another student, how is he? Is he sitting, standing, or doing something else?
He's sitting, leaning in toward him, staring him in the eyes.
Okay. And you testified that you pulled him away. Can you describe how you did that?
I slid the chair from, I was holding the back of the chair and I slid it back. We had no carpets at that time because of COVID. So it was easy enough to do. And so he hopped off and grabbed the front legs of the chair and pulled them forward. But I was able not to fall, but to still hold on. So I could get it a couple of feet further and then I just sat on it.
So when he pulled the legs, had he stood up out of the chair?
Yeah.
Okay.
Oh, yeah.
So what happens after that point?
I was sitting in the chair and I was talking to the class and not about behavior, about the instruction we were doing. And he walked up behind me and put both of his arms in front of my throat and locked them together and pulled back and down hard. I couldn't breathe. And he didn't let up on it. The only way I got out of that situation was the assistant, the teacher's assistant that I shared with another teacher happened to be in there at the time. She was in the back of the room. So she came up and pulled him off of me and took him out of the room. But until she pulled his arms off, I couldn't breathe.
What, if anything, happened with JT immediately after that? Does he remain in your room?
No, I wouldn't have had it. I would have left if he did. No, Mrs. Parker, my assistant, took him out of the room. But then sometime later in the day, and it got very blurry after that for me, so I can't tell you how long. One of our counselors and our security officer came and brought him back to my room.
So when you say, hold on, when you say brought him back, do you mean JT?
Yes.
Okay.
Yes.
So when
they
you,
each had him, I'm sorry.
When you see him come back to your room with the counselor and school security guard, what happens?
They each had him by one hand and they were trying to get him to move into the room. And he was yelling, no, no, I don't want to go back in the classroom. And I looked at them and I had his back to the doorway so I could talk to them without everyone in the classroom hearing. And I said, well, he's right. He does not belong back in the classroom. What he did was severe enough for me to contact the police and to press charges. And the security officer agreed with me.
Okay, so what happens with JT next?
Well, they told me they were bringing him back to me because no administrator was available to handle the situation.
Okay.
So I said that if he was going to stay in there, I was going to need to leave the room.
Did you in fact leave the room?
I did, but not because of that. I believe they took him back out again, but it's very fuzzy.
Okay.
What I know is by that point, I was so shaky that Mrs. Perter, my assistant, said, go ahead and take a break. And I took my laptop and went to the lounge and got the incident referral form because I wasn't going to leave school without reporting that.
Okay, so hold on just a minute.
Mhm.
You've mentioned an incident referral form. Can you just kind of explain to the jury what that is?
That's if you think the discipline problem is dangerous enough or bad enough that you need to refer them officially, formally to the administrators.
And when you say the administrators, what titles? do you mean?
Assistant principal and principal.
Okay. And who was the assistant principal at Richneck Elementary School at the time that this happened?
Dr. Parker.
And is Dr. Parker in the courtroom right now?
Yes, she is.
Just point her out, please.
She's right there.
Will the record reflect that she's indicated opinion?
I was not able to, can you point her out again? I didn't see your hand.
Yes, she's right there.
Okay, so no.
Thank you, Jim. So you told us that you got an incident referral form, okay? And what did you do with it?
I filled it out and I typed up a whole description of everything that had happened that day because I had had some positive moments with him earlier. So I wanted those included too. So typed up the day and then I attached it to the referral form as the attachment and the explanation of the behavior. And then I went to the office and I saw that Dr. Goodman, the principal at the time, and Dr. Parker, they were in her office at the time.
And did you go into the office?
I went into the office. I told them everything that had happened.
Let me
and
ask you this question. Did you have the incident referral form with you?
I had it in my hand.
Do you know who you handed it to or what you did with it?
I handed it to Dr. Goodman after I explained everything on it to both of them.
I understand. So after you explained everything that was on it, did, if you remember, did Dr. Parker or Principal Goodman react to that in any way? And if so, how?
Dr. Goodman did. When I was talking about the fact that if an attack is occurring, it should never be that no administrator is available to help with it unless there's a worse attack going somewhere at the same time.
Okay. Did Dr. Parker say anything or
No, she was making eye contact. She was looking at me. She didn't say anything. Dr. Goodman said, sort of under his breath, prioritize. And I thought, well, yeah, that's what I wanted him to get from that. And then he told me to go to the nurse and have my neck checked out afterwards.
Okay. That year, did JT ultimately return to your classroom or not?
He did. He returned the very next day. He walked in with his breakfast, and I immediately went to the teacher across from me and said, I need to go to the office so that she would watch both of the classes. And she saw who I had with me, and so she understood. And I just told him, he had his breakfast with him. I said, just bring it and come with me. And so we went to the office and I had him sit down in the waiting area for parents there. And I went into Dr. Parker's office. And I knew at that time that my assistant had to stay in a first grade class all day because the sub hadn't showed up. So I would not have another adult in the room. So what I told her is, I cannot be the only adult in the classroom if he's in that room. And so either he needs to be somewhere else or I'm gonna have to take a sick day and go home.
And was he relocated or what happened?
He must have been, because I went directly back to the classroom and continued teaching for the day. I didn't see him the rest of the day.
Okay. At some point later in the year, does he come back to your classroom?
No.
If there were, and if you remember, any other discipline incidents you saw yourself and you reported to Dr. Parker yourself, are there any such incidents?
With him?
With JT, that's right.
No, I don't believe so.
Thank you so much. I don't have any further questions for you. Please answer any questions of the defense counsel.
Of course. I'm sorry.
Are you all right?
Yeah, I'm okay. I thought he was asking me. I'm
Oh, no,
sorry.
Take a moment to confer.
Hello, Ms. White. You just testified that you reported JT's behavior or his presence in your classroom to Dr. Parker directly when he came back the next day, correct? Okay. And then when you told her that, after that, he never appeared in your classroom again, correct?
Right. And I have heard, but.
No, you don't tell me what you heard.
Okay.
So when you told her that action was taken and JT was removed from your classroom.
He went to another school.
Okay. All right. Regarding the incident referral that you mentioned, do you know whether Newport News Public Schools retained a copy of it?
I was told they didn't.
Okay. And did you have to then supply it to someone else, your own copy that you maintained?
Yes.
No further questions.
Any brief, direct?
Yes, sure. Ms. White, I want to just direct your attention to the incident referral form. You've indicated there was a form. Was that the only piece of paper you submitted?
I submitted the referral form with the attached description of the day.
Okay.
So that I could get the full explanation of what happened, because this little place is not going to be enough.
Understood. And the a description of the day that you attached to the referral form, was it typewritten, handwritten, or something else?
Typewritten.
All right. If I showed it to you, would you recognize it?
Definitely.
May I approach the witness, Your Honor?
You may. You may.
Sure. May I approach the witness, Your Honor?
You may.
What is it that I've handed you?
You handed me the detailed description that I attached to the incident referral form. And
Okay, and is what you're looking at now a true and accurate copy of the incident report as you wrote it?
yes,
Has anything been redacted from it?
well, yeah, but I did that myself for some that I gave to other people.
What was redacted? Is it a category though? I don't know how to spell the words. Is it names?
Names.
Hold on one second. What?
Oh,
Yes, sir.
sorry.
before she even answers that, objection, that document is hearsay, it's an out-of-court statement, it's written, being offered for its truth of what happened on that day. She's testified as to what occurred. She testified that she produced this incident report, but as far as the contents of the incident report, I'm objecting to it here.
The objection is premature. I haven't offered any evidence.
Agreed, premature, not yet right. You may proceed.
The redactions that appear are the redactions that you did.
The names, yes. I don't know what I had at the top.
Okay. Are you sure that that is the incident referral that you submitted attached to the form?
It looks like it.
Okay, it either is or it isn't. Take the time to read it.
Yeah. I was gonna say I write a lot, but yeah.
So is it the incident referral?
Mm-hmm.
Is that yes?
Yes, it's the
Okay.
attachment that I attached to.
Thank you. Judge, I am moving that now into evidence as Commonwealth 6 as a past recollection recorded for one thing, and also as a prior consistent statement, because the defense was alleging that or suggesting that it didn't exist, essentially, in cross-examination.
Defense response.
Your Honor, there was no such situation that it didn't exist. So that's number one. It's still hearsay, is duplicative of her testimony, in all the previous objections that Mr. Rogers lodged. And it goes beyond, I'm sorry, it goes beyond my redirect as well. I mean, my cross-examination.
And also, how is this not bolstering? How is this permissible bolstering? She testified to what she was told happened, I think it was a year before.
Yes.
So, I'm talking to the attorney.
I'm
Thank you.
sorry.
She testified to what she believed happened a year before. Why are we allowing in her written statement, her redacted written statement about that?
Because defense counsel asked whether she gave it to the schools and whether it still exists. And I'm establishing that it does.
Okay, so I guess you're interpreting that as an attempt to impeach. And so you're trying to rehabilitate?
If the objection is hearsay, there's an exception to that. If we want to talk about why it's relevant at this stage, yes, we can go to the relevance rules and find that a prior consistent statement does become relevant when on cross-examination, or does become admissible when on cross-examination, the witness has been challenged as to having a memory or forgetting something. I can find them.
And again, I understand that's where the impeachment comes in, but that's the missing link for me. So, sustained, it does not come in, and you may approach to retrieve the document.
Thank you. So I thank you. I don't have any further questions.
Anything further? Okay, and the status for this witness? May she be excused?
I ask that she be released unless I ask you to release.
Okay, and no objection from defense. Okay, so that means thank you for your testimony today. You are released as a witness. You don't have to go back to that room. You do not have to stay in the courthouse. You are welcome to remain in the courtroom if you'd like. Okay, and watch yourself when you step in. Thank you very much.
Thank you.
Next witness?
Hello, also Alonzo Rawls.
swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Please take the witness stand, sir. Watch your step, and you can adjust the chair and microphone as you need. You may proceed.
Good afternoon.
Afternoon.
Would you please tell us your name?
Rolonzo Rawls.
Mr. Rawls, just a quick reminder that we're not using the names of any children today in court. We'll use initials in place of that. Mr. Rawls, in January of 2023, how were you employed?
I was a school counselor
Where?
at Newport Public School at Richneck Elementary.
All right. And how long had you, as of the January 2022 or 2023, I'm sorry, how long had you been at Richneck?
It probably would have been, between that time, would have been like a year and a half.
Okay.
Not quite 2 years.
And during the course of your time at Richneck, did you come to know a student who we'll refer to as JT?
Yes.
And in the course of your duties, did you receive an assignment related to JT?
Yes. Within this second year at Richneck, I was assigned to kind of be like his one-to-one within a set schedule.
How did that assignment come about, if you know?
I don't recall in its entirety. I do believe that originally, because he was having some issues, they were trying to put a plan in place to help him to adjust into the school and, you know, be more productive. So I believe the administration came with a plan up and they administrator need to help him out within that plan.
Tell us how, if you could just describe for the jury how the one-on-one assignment worked. What did you do?
Well, in the morning when he got off the bus or was dropped off, I would proceed to have him have like a morning session with him, kind of set goals and plans for him in the morning. He would then go to one of the, I believe it was one of the SPED teachers to kind of reiterate those plans. After that, he was working with Mrs. Kovac on some, I think it was like a reading assignment because she was a reading specialist at that time. And then from that point, after her time was up, I would come back, retrieve him, and I would take him to the classroom. I would be with him in the classroom.
Okay. And did you ever speak to Dr. Ebony Parker regarding this assignment with JT?
From my recollection, I don't recall. I just remember this is what they were requesting of me.
Okay. Do you know of any behavior issues that JT exhibited?
Yeah, within his first year there, he exhibited a variety of different behavioral issues where he was out of the classroom or taken out of the classroom for whatever case may be, but it varied from time to time.
Okay. Mr. Rawls, do you know what an SST is?
Yes.
Okay, what is that?
Student support team. It was basically a process or a program to put in place to help to assist him in trying to, once again, be more productive within the school system.
And did the SST plan involve regular meetings?
Yes.
Did JT have an SST plan?
They were in the process of moving forward with SST because I believe they were trying to transition that SST into more like an IEP, which is like a more specialized support system for students, and what's called a SPED system.
Okay. And who all was involved in the SST process for JT?
I know I was currently at that time on the Newport News Public Schools policies. Counselors were one of the main people that ran the SST process. Administration would be involved when available and things of that nature, but it was more so put on the responsibility of the counselors to at least coordinate the SST meetings.
And so at those SST meetings, who would typically attend JT's SST meetings?
It would be either the principal, the AP, myself, or the other counselor at the time, a parent, and if they had any advocates, anyone else that would be willing to be part of the meeting. That's how kind of the group of people would be.
Were parents and guardians of children invited to attend?
Oh, yes, of course, yes.
You've mentioned principal and AP. What's AP?
Oh, assistant principal. Yeah.
Thank you. And as of JT's SST, who was the principal at the time?
During that time, the principal,
I'm sorry, I put you on the spot.
I can't remember.
Okay, do you remember who the assistant principal was at that time?
Dr. Parker was assistant principal during the SSC process within that second year, yes.
Okay. Did Dr. Parker sometimes attend the SST meetings, if you know?
I believe she may have attended some, yes.
Okay. Did there come a time when you decided you no longer wanted to, or maybe that you no longer thought it was useful to have that one-on-one assignment?
Yes, because
Hold on just a moment.
Okay, what happened? I heard something. Object leading, okay, response.
I'll rephrase the question.
Thank you.
Did you ever decide that you did not want to continue the one-on-one relationship with JT?
as a school counselor,
Okay, same objection?
Yes,
Response?
I asked, did you ever decide that you didn't want to continue the one-on-one relationship with JT? He's already established the foundation that he had the one-on-one assignment. And did you decide is a question he can answer yes or no? He did decide or he didn't. I'm not suggesting which of those answers is the right one, so it's not leading.
Okay, I think the leading part is to discontinue the relationship with JT. So I think the proper phrasing would be, did you decide whether or not to continue or discontinue a relationship with JT? So if you could ask that, or do you want me to just?
Go ahead, Judge, if you would like to ask the question.
Did you get the question?
Yes.
Okay, can you answer? Thank you, sir.
it wasn't really a decision of sorts. It was a request as a school counselor at that time. I had many students that I had to serve, and and I felt like it took away my opportunity to service a lot of the other students within the building. So I had a request that if I could be relieved of that duty, so I could also service the other students. Besides, I could still assist. However, it needed to be done with JT, but I also wanted to be able to be service to other students within the building as well.
Thank you. During the time that you were working one-on-one with JT, did you experience behavior issues or witness behavior issues?
Can you repeat the question?
During the time you were working with JT, did you experience or witness behavior issues?
When we were more one-to-one, it tapered off more. He still had concerns here and there, but he knew the relationship we had and me being his one-to-one that I would be there to help to correct or redirect a lot of his behaviors.
And what were the behaviors that you observed of JT at any point that year?
Non-compliant, defiant behavior, refusal to do work, just acting out of sorts where he wasn't following directions, things of that nature.
Would those issues ever be discussed at the SST meetings?
At times, yes.
I'd like to take you to January 6th of 2023. You remember that day?
Yes.
What is the first moment that you realized something might be up with JT?
Objection, leading, assumes facts, not evidence.
I'll rephrase.
Yes, sir.
On that day, did you ever notice anything unusual about JT?
On that day, I didn't even really witness him that day until later, within that evening of the afternoon of that day.
Okay. Did you eventually become aware of a crisis that occurred that day?
It was brought to my attention that after dealing with another student, that something had took place at recess where JT apparently told another student something that
So I understand it's hearsay. Let me walk through that with him. During the day on that day, did you have occasion to speak with any students?
Yes.
And were there any students who shared a concern related to JT?
Yes.
Now, without telling me what the student said, did you describe the student's demeanor, how they appeared at the moment they were telling you the information?
They were very emotional, very sad.
Okay. Again, without telling us what was said, were they referring to something they had just experienced or seen?
I wouldn't say they just experienced it, but they experienced it at an earlier time where they were still holding on to whatever was stated.
Okay. And with that information, without telling me what was said, with that information, where did you go?
With that information, where I went to Dr. Parker to address what are the allegations that I heard.
Okay. Did you ask Dr. Parker to take any action?
I didn't ask her to take any action. It was presented to me that some action was taken at a particular time with something else, and then I requested of her if I could take some action.
Okay, and what action did you ask Dr. Parker to take?
I asked her if I could take the action of trying to search or to check the person of JT.
And what did Dr. Parker say anything?
She responded by saying that at the time, because of the scheduling he had, that his parent or parental guidance will be coming to get him, so that we could hold off at that time.
Okay. The concern and the desire to search JT, did you share your concern without telling us what was said? Did you share your concern with anyone else?
The only person that's I shared my concern with is when I went back to speak to Mrs. Zwerner after I spoke to Dr. Parker.
Okay. Mr. Rawls, at the time that you asked Dr. Parker for permission to search the person of JT, did you believe that you had the authority to do that without an administrator's approval?
No, in my previous experiences, you just can't, in my position, you just can't search a student without some type of permission.
Okay. And finally, Mr. Rawls, as you sit here today, do you wish you had done differently that day?
Yes.
Okay. Okay. I don't have anything further.
Good afternoon, Mr. Ross. How are you?
Yeah, right.
Good. Hopefully I won't keep too long. So on January 6th of 2023, you were a school counselor at Richneck, is that correct?
That's correct.
Okay. And so at some point, was it at the very beginning of the year, did you assume the responsibility of having the one-on-one contact with JT?
Not necessarily at the beginning of the year, no, sir.
But at some point you began one-on-one contact with JT, is that correct?
Yes, sir.
Okay, and how were your initial interactions with JT? Was it positive or was it a challenge?
At times it could have been a challenge, but we built a rapport from the year before where it wasn't as difficult for myself, I would say.
Okay, and so over a period of time, his behaviors began to get better, is that correct?
I would say yes.
Okay, and you were part of the SST team, is that correct?
Yes.
Okay, and you function as a counselor as a part of that team?
Yes, counselor coordinator.
Okay. Would you say that you were in a pretty good position to assess how JT was doing on a given day?
I would say yes.
Okay. Would you say that you had more contact or less contact with JT than Mrs. Kodak, the reading specialist?
I would say we probably had about the same amount.
About the same amount of
Mhm.
time? Okay. And at some point, you indicated that you requested less one-on-one time with JT,
Yes.
but it didn't sound like it was because he was doing better, but it's because you wanted to be able to help more students at the time. Is that correct?
Yeah, from my point of view, it was to be able to be more accessible for more students within it.
Okay.
Okay, if you could speak up and tap that microphone, let me see if it's on. Okay, talk into it so that the court reporter can get your words down. Thank you. So if you repeat your answer.
Oh. Can you repeat the question? Sorry.
So you got to a point where you were spending less time with JT. The motivation for that was to be able to spend more time helping, I guess, more students,
Yes.
more people than just JT. Is that correct?
Yes.
Okay. All right.
Go ahead, and I know we're hearing that mechanical squeaking noise. We think it's a chair, so just, well, you know where it came
No, it
from?
wasn't the chair. It was a voice or something like that.
Well, do you know where it's coming from or feedback?
It seemed to be from my right.
Oh, okay, so again, there are other courtrooms and other lockups
Hello, Ms. Wells. You just mentioned speaking with a student with the first initial of R.
Correct.
Did you ever tell Dr. Parker what R has said to you?
I believe I mentioned what he had mentioned to me, yes.
You believe you did. Do you know for certain whether you
I
did?
can't be certain.
Okay. Would you be surprised if you did not do that?
No, I wouldn't be surprised.
Okay. No further questions.
Any further from the Commonwealth?
Based on that, I'm going to need a couple of minutes
Okay.
before redirect, I guess.
All right. So we'll take a good time for stretch break and after lunch restroom break. So it's 3:25. Let's come back at 3:35. Sir, so you're still on the oath, but you can step down and retire to the witness room, and we'll bring you back out. And we'll have the jurors go back to the jury. Thank you all. 10-minute recess.
Please rise for the jury.
Honor, may I approach counsel briefly?
You may. All right, so if you resume the witness stand, and the sheriff, we can bring the jurors back up.
Yes, ma'am.
Yes, you need to come and connect audio. Oh, please come on up. Okay. Thank you.
I got this one.
You
Is
got
there
that
another
one.
one?
What about the other one? He said it's on, okay.
Yeah, I turned both of them on.
Okay, thank you.
Please rise for the jury.
Thank you, sir.
14 jurors in the box.
You all may have a seat, thank you. You may resume your redirect. I'm not sure, redirect or redirect?
This is redirect.
Okay.
Yes, be quick. Mr. Rawls, thank you. I believe you indicated to defense counsel that you didn't remember what you had told or whether you told Dr. Parker about the incident at the time you asked for permission to search the backpack. Is it true that you don't remember that?
It's been a while, so I don't
Sure.
know.
Understandable. Did you give a statement to police in this case?
Yes.
And if I were able to provide you with a transcript of that, might it refresh your memory about what you said to Dr. Parker? Okay, may I approach, Judge?
Yes, and you responded yes, correct?
Yes.
Okay, he nodded his head, I just wanted to make sure it was recorded. Yes, you may approach.
Thank you. I'm just handing you this document. I want you to take a look and read there where I put a pink Post-it note. And after you're done reading, look up and I'll ask you a question.
He said,
Oh, no,
Hold on, don't read it. Yeah, sorry. Read it to your. Just read it silently, and then I'll ask you a question about it. Sorry. And does that refresh your memory about what you said to Dr. Parker regarding the incident?
to an extent, yes.
Okay. Would you just tell us then what it was you said to her?
I'm looking at the witness. At this point, he looks like he's looking at the page, and he's going to be looking at the page and then advising. So his memory has been refreshed.
I'll take it back.
Okay.
Okay, so what's your,
May I approach?
okay, you just like him to retrieve the
I want
page?
this done properly, yes, Your Honor.
Yes, may I approach?
You may approach.
Thank you.
And ultimately, for pardon, the legal principle is you can't read from that statement. You can refresh your memory, but you need to testify from your memory. Okay.
Based on, now let's refresh, if he has an independent recollection.
Well, he said to an extent, so we'll flush it out and we'll give you the opportunity to cross. Go proceed, Mr. Jenkins.
Having refreshed your recollection, do you remember what you said to Dr. Parker prior to asking to search the backpack?
Yes, when I spoke to Dr. Parker, it was already relayed to me that a book bag was searched from JT and that nothing was found within the book bag.
Do you remember if you confirmed with Dr. Parker that you and she knew what you were talking about? Or who?
I know enough that we confirmed that we thought something may have been in the backpack, yes.
Okay, thank you. I don't have anything further.
And Mr. Rawls, and from what you just recounted, nothing was in the backpack, correct? It had been searched and nothing was there, correct?
That's what was told to me, yes.
Okay. And at that point, you did not believe there was any credible threat, correct?
Well, that's when,
Objection asked and answered on recross.
No, I'll withdraw the question, Your Honor.
All right, thank you. All right, anything further for this witness?
No, Your Honor.
All right, and the status for Mr. Rawls, may he be excused of this, he needs to remain.
I'd ask, oh, I'm sorry. No, I'd ask that he be released.
Oh, no, we're gonna ask that you be known.
So we're gonna ask that he be constructed, I agree to that, we'll ask that he be constructively sequestered and remain available for recall.
Are you, is that suitable to the defense?
Yes, sure.
Okay, and do you all have his phone number?
No, I'm all set.
But you have,
Absolutely, I do, be happy to facilitate that happening.
okay, so Mr. Rawls, what that means is you are still a witness, you still have the ability to be recalled. So do not discuss this case, do not discuss your testimony, but you do not have to stay in the courthouse, you do not have to stay in the witness room. You can leave and go about your daily business. You will either get a phone call, 1, to come back to the courtroom, or 2, that the trial is over and that you are no longer a sequestered witness. All right, any questions, sir?
No.
All right, thank you, you may step down. Next witness.
Megan Danielle.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? Thank you, ma'am.
You walk around, please, to the witness stand, watch your step. The chair and microphone are adjustable. All right, you may proceed.
Good afternoon. Would you please tell us your name?
Megan DeLeon.
Ms. DeLeon, do you have a daughter?
I do.
I want to just caution you, and I know we've discussed this, but during the course of this trial, we're not using any children's names, only using initials or referring to your daughter if you prefer. Back in January of 2023, was your daughter attending school?
Yes.
Where?
Richneck Elementary School.
Is that here in Newport News?
Yes.
And what are your daughter's initials?
SD.
On January 6th of 2023, did you become aware of an incident that caused you to go to the school early?
Yes.
And when you got to the school, did you immediately see SD, your
No.
daughter? Do you eventually see her that day?
Yes, when they bring her out to me.
Okay. When you first see her, describe, without telling me anything she said, just describe her demeanor, how she appeared to you and how she interacted with you.
Initially, she just seemed happy to see me and her dad. It was later on in the evening when she kind of showed different behavior.
By different behaviors, you mean different than prior to the events of January 3rd? Describe what behaviors you observed.
Just that evening, it was a very hectic day, so we just ordered a pizza in and just tried to put some show on to kind of, but the doorbell rang just for the pizza and she just got very scared, jumped from her seat, the sound of a doorbell and other sounds like that for many months to come just scared her.
What kinds of sounds would scare her?
Slamming of a door, I know just loud bangs. She described the sound as a ladder falling when the gun went off. So loud sounds have startled her.
I'm going to object to her statement. Sounded like a ladder with gun went off. Sounds like she's justifying his statements that Cassie may have stated. If that's what she has done, I'm objecting to it.
If the request is to strike sounds like a ladder when the gun went off, I agree to that.
Okay, so struck, don't consider that, please. Next question.
So what other behavioral changes, if any, related to SD did you notice in the immediate days and weeks?
Not understanding why this happened. She loved her teacher. The teacher was kind, and she just understood why we want to hurt her.
And who was her teacher, if you know?
This morning.
So Ms. Zwerner, was Ms. Zwerner's classroom her homeroom?
Yes.
As a result of what you observed with SD, did you seek help for her of some kind?
Yes. We went to just regular counseling through our insurance, and then also spiritual counseling through my church.
And how long did that go on for?
6 months.
These are the injuries that the neglect caused, the trauma to the children, and I believe that that is relevant.
So I'll allow it, but do you have additional questions down this line, or do you have additional questions in this line of questions?
Only to elicit any additional different things that she noticed in her daughter.
Okay, I'll allow it. You may proceed.
Okay. We're from January 3rd to present. Any additional things you've noticed in your daughter that were not present prior to the January 3rd incident?
She's very, she doesn't want to talk about it. She keeps everything a close hold. She holds in a lot of feelings and emotions. Recently, she went back to counseling. This is the time they said to start doing it, to give her some time and re-engage with the counselor. And they said that she has depression, anxiety, and one other thing where she's always on alert all the time.
Thank you. I don't have any more questions for you, but thank you.
Good afternoon, Ms. Danielle.
No.
You were never inside of Richneck Elementary School on January 6, 2023, correct?
In the building? No.
Okay. And you did not encounter your daughter in the building, correct?
Right out front. No, they brought out to me.
Okay. You filed a civil lawsuit arising from the events of January 6, 2023, correct?
Yes.
In this courthouse, correct?
In this courthouse, well, through Newport News, yes. Is that what you mean by that?
There's a pending lawsuit in Newport News Circuit Court, correct?
Yes.
Okay. And you've named Dr. Parker as a defendant in that case?
Well, I prefer not to talk about my pending civil case.
Well,
it's more of a
I'm
personal.
going to judge and ask that we not talk about a child's civil matter on TV, that we have to not continue the broadcast while she's speaking about the civil suit that is her child's, really, not hers.
The court's ruling will be the same as earlier, so the objection will be overruled. She's been cautioned that we're only using initials, but the question party is a right to cross-examine about interest in case. And you just asked who was the named parties, not what your opinion is. And I think you said I prefer not to share my opinion on it. so non-responsive as well. Repeat your question, Mr. T.
Okay. In that civil lawsuit, you had named Dr. Parker as a defendant, correct?
Yes, I believe so.
Okay. And you are seeking money damages from the defendants in that case, correct?
I'm more seeking justice for my daughter and what she went through.
And you are seeking money damages from the defendants in that case, correct?
Yes, there is settlement and discussion with that, yes.
Yes, but the loss, I know there are settlement discussions, I'm sure there are. But in terms of what you're asking for in that lawsuit is money, correct?
Yes.
Okay. And you believe that a criminal conviction of Dr. Parker would help in that case, correct?
I don't have any opinion about that or anything to say about that.
Okay. After January 6th, you requested that your daughter be transferred to a different school, correct?
Yes,
And that request was refused by Newport News Public Schools, correct?
it was.
Okay. No further questions.
Thank you. Anything further from the Commonwealth?
Your Honor,
And the status of this witness?
we'll ask that she be released. And we're also calling Nicholas Daly out.
Any objection from defense to this witness being released?
No, Your Honor.
Thank you, ma'am, for your testimony. You are released as a witness. You are welcome to remain in the courtroom, or you may leave the building. Thank you.
Thank you.
And the next witness's name again, I'm sorry.
Nicholas Daly.
Okay, Mr. De Leon, please.
Your Honor, I'm going to object to the testimony of the next witness because I believe it's cumulative. I don't think that we'll be able to testify to anything other than his.
I don't know who they are, so, okay, tell me why it's cumulative.
I don't know.
Mother and father of the child.
Okay, it's one witness, I'll allow, I mean, are you bringing out 5 relatives for the same child?
Absolutely not.
Okay,
Absolutely
you can
not.
come out
That's-
overruled. Mr. De Leon, please.
Do you swear affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
Yes. Sir, please take the witness stand, watch your step, chair, microphone are adjustable. You may proceed.
Good afternoon, sir. Would you please tell us your name?
Nicholas De Leon.
Mr. De Leon, just a reminder that we're not using the names of any children at all, including your own. But do you have a daughter?
I do.
And what are her initials?
SD.
And where did SD attend school?
Richneck Elementary.
Okay. And are, as of January 3rd, 2023, were you, let me ask the question like this. Who is SD's mom?
Megan De Leon.
Thank you. Between the time of January 6, 2023, before and after, were there any changes that you noticed in your daughter SD after that hadn't been there before?
Yes.
Could you just describe what you personally noticed or observed, but not anything that she said to you?
I noticed that she was anxious, depressed, very not like herself, as in being quiet, distant, couldn't sleep.
How long did that persist?
Quite some time, months.
Did you and her mom seek any sort of treatment for her?
Yes, counseling and spiritual counseling.
Has it helped?
I think it's hard to say at this point. She's still going through counseling. It's been up and down, I think, with her.
And just to confirm, whose class was SD in?
Ms. Zwerner's.
And was that at Richneck Elementary?
Yes, it was.
Thank you. I don't have any other questions for you. Please answer any further questions.
Good afternoon, Mr. DeLeon.
Good afternoon.
All right, you mentioned your daughter SD. You don't have any knowledge of whether SD was in the classroom when Ms. Zwerner was shot, do you?
I was not there in person, but that is her classroom.
I understand. But you don't have any idea whether she was actually in the classroom, correct?
From what I understand, that she was in the classroom.
And what are you basing your understanding? Is that from somebody told you?
Again, I was not there, so
Okay.
I can't verify that, but
So
I was
you can't
told
verify
that she
I'm
was.
asking you to tell me what you were told. That's hearsay. Okay. Now, you are aware that your wife, or I don't know the status of your relationship, but Megan DeLeon has filed a lawsuit on behalf of your daughter in this courtroom, correct? I mean, this courthouse, correct?
Yes.
Okay. And that you're aware that Dr. Parker is a named defendant in that lawsuit, correct?
That's correct.
Okay. And you're aware that money damages from Dr. Parker are being sought in that lawsuit, correct?
Correct.
Okay. And so you have a financial interest in a criminal conviction of Dr. Parker, correct?
I don't. It's on behalf of my daughter.
Oh, so you believe your daughter has a financial interest in the conviction of Dr. Parker?
Today, that's a separate case. That's a
Answer-
separate,
just answer my
that's a
question.
separate suit.
Answer my question. Do you believe that your daughter has a financial interest in the criminal conviction of Dr. Parker?
Today, I don't believe so, no.
Do you believe that a criminal conviction of Dr. Parker will help in that civil lawsuit?
Objection asked and answered. You said no.
No, it has not been asked and answered. Your Honor, I asked a different question.
It was a different question, and I think you already answered it. Are you asking if it to be struck?
Yes, irrelevant and duplicate.
Overruled, and your answer was no, sir, if I heard you correctly?
Correct.
Okay, thank
No
you. Any
further.
additional questions?
No further questions, Your Honor.
Any redirect?
No, Your Honor.
And status of this witness?
I would ask that he be released.
Any objection? Okay, thank you, sir. You're excused from your duties as a witness. You may stay in the courtroom or leave, as you see fit. Next witness?
Commonwealth will call Tanisha Richardson.
anything further for this witness?
No, Your Honor, I ask that she be released.
Any objection to her being released?
No, Your Honor.
Thank you, ma'am. You are excused as the witness. You may stay in the courtroom or leave the building. Next witness.
The next witness will be Ramon Gonzalez. Your Honor, I anticipate having this witness plus one more.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth?
I do.
You say, take the witness stand, watch your step. Answer questions for counsel. Thank you.
Thank you.
Good afternoon, sir. Would you
Good
please-
afternoon.
Would you please tell us your name?
My name is Ramon Sebastian Gonzalez Hernandez.
Thank you. And I would like to, just a quick reminder that during this trial, we're not speaking the names of any children at all, and only
Correct.
using initials. Do you have a child?
Yes, sir.
What are your child's initials?
GG.
And did your child attend school, did Gigi attend school in January of 2023?
Yes, he did.
What grade was he in?
First grade
And where did he attend school?
at Richneck Elementary.
Do you know who his homeroom main teacher was?
Yes, I do.
Who was it?
Abigail Zwerner.
Did there come a time on January 6, 2023, when you had to unexpectedly go to Gigi's school, Richneck?
Yes, I do.
And when you arrived at the school, did you immediately see Gigi?
No, I did not.
Okay, stay with me and let me walk you through it.
No worries.
So eventually, did you see Gigi at the school?
Eventually, yes.
And when you saw him, could you please just describe, without saying anything that he said, describe his demeanor, how he was acting, and how he appeared to you?
He walked out of the school with a look on his face like he had seen a ghost, pretty much. I was crying myself. He wasn't crying, but he was in shock, like complete, utter shock.
And from that moment forward, did you notice any changes in behavior from Gigi as opposed to before January 6th?
Yes, at home he was a little bit snappier with his brother. Whenever they would argue, he would be a little bit more aggressive. Other things like he had to sleep with him every night because he just felt more comfortable. Bedwetting almost every night. Things like that.
And were all of those things new after January?
That was new after that. He loved to sleep by himself before that.
And did your family seek some help and treatment for Gigi?
Yes, we did. Right after the incident, we went, I want to say 2 or 3 times. And he was very adamant that he didn't want to go because we wanted to keep his life as normal as possible after the incident. So wasn't trying to force it down his throat, you know.
And has he, at any time between then and now, has he sought any treatment? beyond
Not
that?
since then, no.
And how long did any concerning behaviors that you've described last?
It still lasts to this day. Getting better gradually, I think. But still, he has a lot of mood swings, and the whole big wedding thing still happens. Yeah, it's pretty rough.
Did your family incur any expenses as a result of this?
As far as with the
For GG, as a result of this, did you have some expenses?
not with the therapy that was provided, so we didn't have any expenses as far as that.
Okay, thank you. I don't have anything else for you.
Okay, thank you.
Good afternoon, Mr. Gonzalez.
Good afternoon.
You weren't at Richneck Elementary School on January 6, 2023, correct?
I picked up my GG that day.
But you were not inside of the building, correct?
No.
You learned about the shooting after the fact.
Mhm.
Did the school contact you at the time of the shooting?
No, I had a friend of mine, a coworker, contact me and told me about the shooting.
But did the school ever contact you?
Afterwards, yeah.
How long after?
I would say an hour and a half.
Okay. Your child was not in the classroom where the shooting occurred, correct?
Yes, he was.
Okay. And you're saying he was a student in that classroom?
He was a student in Ms. Zwerner's classroom.
Okay. And you filed a civil lawsuit in this case, stemming from the events of January 6, 2023?
I don't feel comfortable talking about that.
Your Honor, I'd like to know my continuing objection.
Okay, so noted. Sir, you do need to answer the question, please.
Yes.
Okay. And you have named Dr. Parker as a defendant, correct?
Yes.
All right. You're seeking money damages from Dr. Parker in that case, correct?
Yes.
Okay. And a criminal conviction of Dr. Parker would be helpful to that lawsuit, wouldn't it?
I'm not sure about that.
Okay. No further questions, Your Honor.
Anything from the Commonwealth?
No, Your Honor, that's that he be released, please.
Any objection from dissent?
No objection, Your Honor.
All right, thank you, sir, for your testimony. You may step down, and by release, you can leave the courtroom or stay in the courtroom, but you're no longer needed as a witness. Thank you.
That way? And the Commonwealth will call Sarah Gonzalez.
Your Honor, again, we're going to object. This is a duplicative witness that adds nothing to the case. This is the last other parent of the child, the second parent of the child.
So noted, overruled. You can bring out the witness. Thank you. And this is the last witness?
This is the last witness.
Okay. And I'm not rushing, I'm just trying to line up
I
the
understand.
day.
I understand. I will take a moment to double check that this is
Understood,
that we're
understood.
in the, yes.
Do you swear or affirm the testimony you're about to give is the truth, whole truth, and nothing but the truth? Thank you, ma'am. Please take the witness stand, watch your step, chair and microphone are adjustable. You may proceed.
Good afternoon. Would you please tell us your name?
Hi, Sarah Gonzalez.
Ms. Gonzalez, do you have a child?
Yes.
Remember that we're only using initials or referring to your child as my child. What are the initials of your child?
G.
And who is Gigi's father?
Ramon Gonzalez Hernandez.
Okay. I want to take you to January 6th of 2023. On that afternoon, where were you when you first see Gigi?
After the incident, when I saw him,
When you first see him on January 6th, 2023?
at our home.
Okay. When you first see him at your home, is it still on January 6th?
Yes.
And do you know roughly what time it would be?
It was in the evening.
Okay. Could you just describe for me Without telling me anything he said, but could you describe his demeanor, how he appeared, and how he was acting toward you?
My husband came home with him in the car and he came out. He was like he had seen a ghost, kind of. He was white and his eyes were very big. And he was just kind of, I've never seen that look before, but it was kind of like he was in shock.
Were ongoing after that day, were there any issues with Gigi that you noticed that were different than prior to the January 6th?
Yes.
Describe those to us.
He couldn't sleep by himself anymore. He had to sleep with someone else, and it just to this day he still sleeps with his older brother, and just refuses to sleep by himself. And he frequent bedwetting started occurring after that, and frequent bouts of losing his temper, and just becoming angry, things like that.
And for how long did those things last?
For a long time. It's improved, I would say, but it still occurs. It was very frequent after that for quite some time.
Were there any other major life adjustments that your family had to make as a result of what Gigi went through?
Just trying to internalize it and, move forward. And, it's the impact on my husband and myself. It was pretty significant and caused a lot of anxiety and, just.
I agree, Jeff. We won't go down that road.
Okay, so we won't consider that just to the child. Next question.
I don't have any more questions. Thank you so much. Please answer any questions from the defense counsel.
Good afternoon, Ms. Gonzalez.
Good afternoon.
You have filed a civil lawsuit in this courthouse as well, regarding the events of January 6, 2023, correct?
I don't feel comfortable speaking on that as it's relevant to my son.
Objection noted, and you need to answer, please. Repeat the question.
You have filed a civil lawsuit related to the events of January 6, 2023 in this circuit court, correct? And you have named Dr. Parker as a defendant in that matter, correct? And you're seeking money damages from Dr. Parker and the other defendants, correct?
Am I still liable to speak on this?
Yes, ma'am, you need to answer the question.
Yes.
Okay. In fact, you and several other parents are represented by the same attorney, right?
Objection, Judge, that is not who they are represented by. The civil suit is not in any way relevant.
I think it's relevant. We have a series of witnesses, all filing civil lawsuits, and represented by the same attorney. I think it's totally relevant to these proceedings.
And I object to counsel saying they're all represented by the same attorney. He's not testifying.
Correct, that's not evidence.
Well,
I'm going to sustain the objection. Who their attorneys are is not relevant. But, that there's a lawsuit is relevant for cross-examination. Next question.
And a criminal conviction of Dr. Parker would help in that lawsuit, right?
Imagine, yes.
What was your answer? I'm sorry?
Yes.
Okay. So you have a financial interest in these proceedings, right? I'm sorry?
I imagine that's part of it, yes.
Okay. No further questions.
That's all for this witness, Judge, and I would ask that she be released.
Any objections? Okay, ma'am. So you are excused from being a witness. Thank you for your testimony. That means you can stay in the courtroom or you may leave. And watch your step down.
Judge, may I have just
Absolutely.
Less than 1 minute.
Yes, Dr. Ginsburg. You can sit down. Thank you, ma'am. And the sheriff will direct you.
Your Honor, the Commonwealth Press.
Your Honor, we will have motions to strike, but I do want to take time with co-counsel and defendant to make sure that we're have every base fully covered. So I'm going to ask the court to consider going recess for the beginning of the day, and then we'll come back first thing tomorrow and make our motions and presenting evidence on behalf of the defense.
Kamala, in terms of proceeding in that chronological fashion, your position.
I'll submit to it.
Okay. All right, so to the jury, we take up the motion to strike outside of the presence of the jury. It's 4:25 today, and they're asking to do so in the morning. So I will kindly ask you all to report back and would you like the jurors to report? What time is council prepared to do motions to strike in the morning? 8:30 or 9? And I'll give that an hour and ask the jurors to report an hour after that.
Any time is fine for you.
Understood.
Your Honor, we can be prepared for 9 o'clock in the morning.
Say that start at 9?
Yes, 4 motions to strike. Yes,
4 motions, and ask the jurors to report at 10.
Yes, sir.
Okay. All right, so thank you again for day 3. You have the same cautionary instruction. Please do not discuss the case, research the case, allow others to discuss it and or share their discussions and thoughts and opinions with you. I know that's hard. I know this is a high profile case, but that is important to the integrity of the process. And please report at 10 a.m. Are there any issues, anything I can assist you all with? Okay, and last, please, I will not be able to court to provide lunch tomorrow. My assistant's off. And she's the one who, while we're here, actually goes to pick it up. So bring your lunch or be prepared to go out to get food tomorrow. All right, thank you very much.
Thank you, Madam.
Please rise to the jury. Make sure you leave your notebooks. Somebody's coming to get you. Coming to get you. Coming to get you. Not right now. Yes, sir. We'll get you later. I will love. They're gonna take care of you right over there.
Thank you, Sheriff. Anything else from the Commonwealth of Defense to take up before we make our evening recess?
No, Your Honor.
All right, we'll be in recess. Thank you. See you all at 9 a.m.
Thank you.